Fresh matter.
Fresh one. Friday.
Similar period, Lordship. Transfer and posting.
Maybe.
Problem.
Your Lordship, I would like to mention this item. This was last listed on 16/5/25. Actually, it was there for hearing. So, can it be on fixed on 2nd, Lordship?
2nd of June.
Yes, Lordship. For hearing.
My Lordship.
Is it for hearing?
It was already heard and it was.
Normally, it is not to be listed for hearing. It will be listed for
So-
admission orders. Then we can fix a date for
Okay,
hearing.
Lordship. Then I'll say orders. Let it
Orders.
come on 2nd or for orders, and then we will.
All right.
My Lordship.
Tell your friend.
I want to mention one contempt case, case number 269, 2026, along with petition 2689, 2020 on 1st June, one day next.
Why?
Because there is urgency.
Oh.
It is a case to dividing the pensions among two widow wives of a one husband. The husband died in her nest. He was a fourth grade.
Have it on 2nd or 3rd?
Pardon?
Let it be on 2nd, 3rd, 4th.
Second
2nd.
Maybe.
All right, 2nd.
2nd June.
Yes.
I did nice.
Lordship, I beg to mention item number 16. We've received our instructions. We seek for a week's time to file our.
No, that you mentioned when the matter is called up. Why are you mentioning this now? Yes.
Maybe. That matter may come for order. Earlier occasion, my lord, taken 2 weeks time by the respondent for instruction on February.
No.
Next week, man.
Let it be sometime around what? 10th?
Okay.
10th of June.
May I
Yes.
please? Lordship, I beg to mention for listing. The matter was listed day before yesterday, and an interim order was there, ma'am. So, Lordship,
Day before yesterday. What happened? Interim order?
my lord, there is no order because Lordship was.
It was held by some other bench.
No, my lord. Item up to item 48.
Okay.
My item was 49. my lord.
Friday.
Friday, my lord.
May I present your Lordship? Therefore, listing of the case, my lord.
Hmm.
This was service, my lord. 2168. Lavender Sarkar. On the next 3 June, my lord. And another competition happened in Central Department, Army Port Department.
Hmm.
Competition happened, my lord. That this case may be listed on 5th June, my lord. Orip KRI.
All right, 5th.
Wait, please, Your Lordship. Lordship, the concern of the other side, I mentioned item number 19 for adjournment.
19.
Lordship. Lordship, a
Item
longer date may be given because Your Lordship, some talk.
You are for the petitioner.
We are for the applicants in the IA.
19.
Yes.
Why are you taking time after time? What is the
Lordship,
status
we
here?
require some time for
We'll dismiss it as and when you
Lordship.
think it is necessary, you come and file again.
Lordship.
Why? What is the fun in deferring a matter?
Lordship. Some more time,
You wait.
Lordship will.
You wait, we'll call up the matters. Yes.
Oblige.
May please, your Lordship. Also regarding item number 20, Lordship, conducting counsel Mr. R.S. Mr. had some difficulty is out of. Lordship, I have already taken.
You're on whose behalf?
R.S. Mr. Lordship.
R.S. Mr.
Petitioner, Lordship.
Oh.
So this matter.
Why IA is filed in arbitration?
I will take for implement of party, Lordship.
For that also you are taking an adjournment.
Conducting counsel is out of
Huh?
station. Conducting counsel
No,
is
no,
out.
you remain. You remain. It's for the IA for implement of parties. At least a notice can be issued instead of adjourning it.
Already filed the objection also.
You filed objections.
It's
You are
already-
not for the applicant.
No.
Who's for the applicant?
Consider the application.
So you wait for the matter to be called up. Let the applicant be there. Yes.
Lordship, my lord, I beg to mention for listing of matter which is listed in the part 2 hearing, my lord.
Hmm.
I pray for that maybe listed, my lord, for
I don't know. It is already listed.
the part 2 hearing, my lord.
So you mentioned it, upgrade it. Why are you asking for listing it again?
My lord, there's some emergency, my lord.
We'll take up today. Part 2 matter.
Maybe on Tuesday,
You
my
said
lord.
urgency. We are ready to take up today.
On
You wait
Tuesday,
for the part 1 list to be over. What is the item number?
it's 113.
113. You give the
But,
number.
my lord, the previous, I have not brought the big, my lord.
Then you are pressing for urgency.
My lord, I pray for next week, my lord.
Next week, 2nd.
Obliged.
But it is not listed in part 1. It will call it up in part 2 from part 2 only.
Another prayer, my lord, on behalf of MP Sharma, my lord, item number 64, my lord, supplementary.
What is wrong in 64?
My lord, I pray for the adjournment on behalf of MP Sharma.
Why?
He is out of station, my lord. The conducting counsel is out of station.
What is the IA for?
My lord, the I is for praying for injury, my lord. I pray for the adjournment for the day, my lord.
You are appearing for the petitioner,
My lord, for the MP Sharma on behalf of
but you are for the petitioner
Yes, my lord.
in the writ petition.
Yes, my
How
lord.
you making mentioning on behalf of the other
My lord,
opposite
here
counsel?
the conducting counsel is MP Sharma.
In for the petitioner.
Yes, my lord.
Okay. 64 adjourned to be listed after 3 weeks on the request made on behalf of the petitioner.
May I
Yes.
please, your lordship, with the consent of the petitioner, I beg to mention item number 25 and 26. Your lordship, that the conducting counsel, Mr. KP Pathak, is out of station. Kindly.
25, 26 stands deferred to be listed after 3 weeks on the request made on behalf of the conducting counsel.
Much obliged.
Yes.
Lordship, praying for listing the matter for motion on Friday,
Fresh matter. When was it filed?
on 21 May.
Okay.
Of this lordship.
Friday.
Please, Lordship, I pray for listing of a matter for admission, Lordship. Can it be on 5th June, Lordship?
Admission matter.
Yes.
9, 10, 11. 9 June?
Can it be on 8th June, Lordship?
No, 9th. 9, 10,
My
11.
senior- Some person difficult.
Then you choose another date. Can't be on a miscellaneous day. You want an admission hearing, isn't it?
Yes.
Yes. You get his dates and come back again.
Lordship, on 8th.
Not 8th is not possible.
Okay, Lordship, then on
9th.
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 Obliged, Lordship.
Beg to mention item number 40, 41, 42, and 43.
Hmm.
For an adjournment.
Why?
Second counsel, Mr. Arusen, he is unwell, he is unable to come to court today.
40?
40, 41, 42, and 43.
40,
They can take consent of
40
the
to 43.
other.
Adjournment is offered on the ground of Mr. R. Hussain, the conducting counsel. As it is submitted, the counsel is unwell. Matter stands deferred to be listed after 2 weeks.
Obliged, Lord.
Yeah, please. Lordship, I beg to mention item number 45, as my senior counsel is out of station.
This is for further hearing. Wait for the matter to be called up.
German slip is already circulated. with
But
the
it's for further hearing. You are appearing for petitioner or respondent?
petition.
Petitioner. Have you not seen it listed for further hearing? We release it. Adjourned item 45 to be listed after 3 weeks. Matter not to be treated as parted.
Lordship, Lordship, we fix a date.
We are not fixing a date. We are giving you time, you get the matter adjourned, as and when your counsel is available, you make a mention, we'll fix a date. Yes, it is a fixed date today, 45. Yes,
May I please, your lordship, I beg to mention
Lordship.
urgent.
Let the matter be called for.
we have already passed an order. What are you doing? You're not doing it today, aren't you? You're not doing it today. We are giving you time because you have circulated the slip. Yes, yes, yes.
May I please, your lordship, I beg to mention urgent listing of the petition.
Hmm.
Kindly allow the matter to be listed on this Friday,
Friday, when did you file it?
21 May.
All right.
May it be just your
Obliged, your
lordship. Lordship, I'd like to mention I'm pending IA for listing for orders, your lordship. Due to some mistake, we had attached in the previous IA to same orders twice. So the court orders are asked to put on record the correct order, and so we are filing this IA, your lordship,
All right, let it come.
on Monday, your lordship.
3rd of June.
Obliged, your lordship. May I please, lordship, I want to mention for listing, lordship, for admission, lordship.
Admission.
Yes, lordship.
Pleadings are complete.
Lordship, all pending matters, lordship, and 19 matters.
Affidavits exchanged.
Yes.
All right, list this matter on 16th of June. Yes. For admission.
Sir, admission matter, listing of.
Pleadings exchanged. Affidavit filed. 16 June.
Similar claim on another matter.
For what? Admission.
Yes, ma'am.
Affidavits are exchanged. Are you sure? All right, you submitted affidavits are exchanged. The matter be listed on 16 for these 2 matters. Yes.
May please your lordship, I beg for listing the matter lordship, whole pending matter lordship. Next week any date lordship,
What is the matter?
matter pensionary
For
benefit lordship.
Pensionary benefit for admission.
For admission lordship.
When was it last listed?
Last listed on 20 February lordship.
20 February, all right, 9th of June.
Obliged lordship.
Yes.
May I appeal to your lordship? On last occasion, respondents would have to construction. Whether by
Why
service considered-
2017? Why 2017 matter you are challenging in 24?
Whether tourism matter matters because the respondents is till date had not implementation by order of Honorable Gauhati High Court, my lord.
What? Which order?
High Court order, my lord.
Which order? Page number.
Page number 29 to 32.
29 to 32. Then subsequently it was forwarded and it was rejected by this letter 23rd November. Yes, respondent, anything?
Yes, Lordship, this page 51 is there. Then we also have an instruction, Lordship. This years old instruction, Lordship. It become little bit heavy, Lordship. It has been put in the DLC meeting held on 20 June 2018, Lordship. So this is there. I have the minute.
What does it say?
It has been placed, but it was considered but rejected, Lordship.
DLC.
Lordship.
Hardly legible.
Lordship, it says.
Huh?
It was
Get a better
sent
copy.
in 24, Lordship. Then I have to get it again,
Get a
Lordship.
better copy.
Lordship. Because the matter was not listed for past 2 years.
Why?
I got it in April 24, Lordship.
Please get a better copy.
Lordship, I shall.
It is submitted by the council to the respondents that in deference to the order of the court dated 14/7/2017, passed in WPC number 4099 of 2017. The Department of IWT, Directorate of IWT, had forwarded the proposal of the petitioner to the Office of the Deputy Commissioner, Dhuri, for being placed in district level committee, state district level selection committee. Stop. Para MS M. Bhattacharya, Learned State Council. Instruction submits that the minutes of the DLC has been furnished to her. And from the minutes, it appears that case of the petitioner was considered. However, the DLC had rejected the same
20 June 2018, Lord.
by its meeting held on 2006-2018. And the case of the petitioner was not recommended due to the 2 years validity period being already over. Rest of the things are not clear.
Lordship.
As the copy of the minutes placed before the court were not very legible, the State Council is requested to produce better copies for perusal of the court. There are Mr. A. Das appears for the petition. List again. How soon can you get it?
Lordship as we get
We
it.
listed again on 8th of, sorry, 5th of February, 5th of June.
June. Lordship.
5th of June.
Deeply obliged.
As per the office note, your lordship, 6526, it's stated that the amended petition has not been received, your lordship, but steps were taken. Inadvertently, it has not come on record. Inadvertently, I think it has not come on record. Later,
You have approached the registry. Office note dated 6/5/26 reflects that amended petition as directed by the court has not been received by the registry. Issuance of notice on the newly implemented respondents has been issued. MS
SG.
S. Jain, Learned Counsel appearing for the petition, however, submits that the steps were taken furnishing the amended writ petition before the registry on.
Inadvertently.
Did you file or you did not file?
It is not filed, Lordship.
You have not filed it.
We approved the registry, your lordship.
Did you file or you did not file?
We gave it for the, we gave it for the thing.
The counsel for the petitioner he submits that due to oversight, steps perhaps may not have been taken. She prays for further time. So, considering the prayer made, this matter after 4 weeks, by which time the petitioners will take steps to file amended post title registry. Stock registry will make necessary endorsements in the note sheet after filing of registry, filing of the amended post title. Sorry, amended writ petition. MSM Bhattacharya for the state, Mr. S. Doctor for revenue.
Under this case, I have prepared affidavit sent for vetting manner. I am for the respondent manner. And department, the same is in process for vetting and signature manner. So department needs some more time.
This is for what? Termination.
Yes, time is for contextual employee.
Is there any interim order?
Yes.
Will issue notice here.
No,
Why
the notice has already been
issued?
yes. All the filing affidavit manner and the same.
No, then why is it listed for motion? Notice has not been issued. Your Mr. MS M. Devi. Dev appears for the writ petition. Mr. E.S. Bhattacharya, CGC respondent. He submits that steps are underway for filing preparation and filing of the affidavit.
Already prepared and sent for vetting.
He submits that the matter be deferred for 2 weeks, 3 weeks, enabling him to file the affidavit. So, considering the submissions made, let this issue returnable 4 weeks. Since the respondents are represented, formal notices are not issued. However, extra copies, if not already furnished, be furnished in the meantime. Interim order passed earlier will continue. Yes.
My lord, this application has been filed for appointment of independent and impartial arbitrator, my lord. That clause you also will see at page 23, small a, type code.
23,
23, my lord, this small a.
small a. This is with railways.
Railways, my lord. That we have been relegated to, my lord. Writ petition was filed before this honorable court, and this honorable court relegated us to go before.
All right.
The
Where is your notice?
notice, my lord, may I kindly see page 37, my lord. Type copy, Annexure 5.
Then after that, what happened?
After that, they appointed their own retired officers, your lordship. So we filed an application that your lordship will find at page 39, last page. As per,
But you requested for appointment of an arbitrator.
as per Arbitration Act, my lord. And Act says, my lord, as per section 12.5, my lord, he has to be, my lord, nowhere connected with the, my lord. And he should be impartial. He was the person who has been appointed, my lord, was retired officers of railway, your lord. So we are not agreeing because it was appointed unilaterally.
So pursuant to the notice,
My-
what communication was issued?
They have issued this communication, page 38,
38.
38, my lord,
Hmm.
saying that they have appointed arbitrator. Now this tribunal also, my lord, dissolved, my lord, because of the letter given by us.
All right. Mr. E. Goyal, learned counsel for the petitioner. MS.B. Sharma. As also Mr. Sailendra Kumarshi, appearing for the writ petitioners. MS.B. Sharma, learned CGC. He has accepts notice on behalf of all the respondents. Therefore, no formal notice need to be issued. However, extra copies be furnished within a period of 3 working days. This is an application under section 11.6 seeking a direction for appointment of an arbitrator in terms of the
Contract agreement.
contract executed by and between the parties in response to a contract executed in connection with where is the work?
My lord, work is, my lord, page 15. Supply of, my lord, boulders, my lord.
Where is it?
My
there?
Name of work, manufacturing supply, page 17, my lord, 17.
Yes, page 17 in connection with so and so work, huh? Name of work. The respondents are permitted to file their objections if any. It's taken after 4 weeks.
My lord. My lord, friend is coming from outside, my lord.
You're coming from which place? 4 weeks. Let it be 3 weeks.
3 weeks.
Then let it come on.
Lordship, 3 weeks will be short period, Lordship. Let it after vacation.
4 weeks will be after vacation.
My lord.
All right. Let it come immediately upon reopening. Based on 15th of July.
15.
Friday, madam. Friday.
Mhm.
Friday.
You want it on Friday? All right. Then
17.
17 July.
Deeply.
Lords, I appear in item 5 for the petitioner. Lords, this is a section
Yes.
11 application seeking appointment of an arbitrator.
You are muted. Yes.
Lords, this is a section 11 application seeking appointment of an arbitrator. Lords, I have sent a.
We still can't hear you.
Lords, am I audible now?
Yes.
I'm so sorry, Lords. Lords, this is a section 11 petition filed for appointment of an arbitrator. The clause, my lords, will find at page 173 and my notice of
Page,
invocation.
page number
173 is the clause.
173.
Yes, my lords. It is within the jurisdiction of this court. I must inform my lords that this is one in a series of 8 projects between the same parties. And at item 35 today, an earlier section 11 petition where my lords has issued notice is also pending. My lords can take it up together as well, since they are in any case
We'll have to issue notice here.
Yes, my lords. So I'm only saying that since my learned friend represents the department in the same series, it can be done. He can accept advance notice as well if my lords deems fit.
Mr. Gupta, are you accepting notice here? I heard counsel for party. It is an application in the section 11(6) filed by the petitioner as the request made by the petitioner in section 21 by issuing the section 21 notice, calling upon the respondents to appoint arbitrator as not adhered to as per clause 63 of
Please,
the
ma'am.
contract agreement.
That would be 64, my lords.
64.
Yes, my lords. At page
64.
170.
64 of the GCC, they have
Yes.
not annexed the contract agreement.
64.
64.
Yes, my
Where
lords.
is 64?
Page 177.
75.
77.
177. That is the amended correction slip, and the original clause, my lords will find at page 175.
70. Clause 64.3.b.
Yes, my lords.
In
60.
connection, where is the work mentioned? Nature of the work, name of the work.
My lords, the contract agreement is annexure 3, page 58.
58.
Yes, that is the contract clause. Sorry, the contract agreement, my lords.
No. Where is your LOI?
My
Or the letter of award?
The letter of acceptance, my lords, is at page 51, annexure 2. The contract is at page 58, annexure 3. And the GCC is what I'm relying upon to show my lords the arbitration clause.
We want to know the name of the work that you are allotted. Where does one find it?
That, my lords, will find at page 51 in reference. It says tender number 01 TSK.
No. There must be a proper reference here.
Yes, my lords. This is a project at Margarita Station, MRG Station. That is the full name of the project. At reference number 1, tender number along with closing date at TSK division provision for FOB 12 meter wide at MRG
Page
station.
55. In connection with the work. Page 55, subject to TSK means Tinsukia division, provision of FOB 12.0 meter wide, so and so. In connection
MRG
with
station.
Station scheme. Page 55, reference 1. Since the respondents did not yield to the request made by the petitioners, his application under section 11(6) has been filed. Error issue notice. Since Mr. Gupta has already accepted notice on behalf of the respondents, notices are waived. Extra copies be furnished within a period of 3 working days or 1 week.
My lords may keep it for 1 week, yes.
1 week. And the respondents may file their objections before the next returnable date. Matter be listed again after 4 weeks.
Obliged, my lords.
May I please, Your Lordship?
Yes.
I filed this present petition for interest in delayed service payment, Your Lordship. On last occasion, Your Lordship asked about the provision, Your Lordship. Is Your Lordship Central Services Pension Rules 2021, Rule 65, Your Lordship.
TCS pension. $72.
2021 pays your lordship 525 within bracket 84.
520.
5 within bracket 84 page.
Yes.
Rule 65 your lordship.
65.
Interest on delayed payment of gratuity, pension and family pension. In all cases where provisional pension or provisional family pension or provisional gratuity has not been sanctioned in accordance with this rule, or where the payment of pension or family pension or gratuity has been authorized later than the date when its payment becomes due, including in the cases of retirement or otherwise, then on superannuation. And it is clearly established that the delay in payment was attributable to administrative reasons or lapses. Interest shall be paid on arrears of pension or family pension or gratuity at the rate and in the manner as applicable to General Provident Fund amount.
Yes, Mr. Purva.
Lordship, in Vandana 4 is the second one, Lordship. And for this, item number 7 was pending.
Will issue notice here. I
Yes,
think
yes,
notice has not been issued here. Heard Mr. A.R. Shah, the council petitioner, and Mr. C.K. as state CGC appearing for the respondents. Stop the petitioner claims interest on delayed payment under 65. Is it 65? Rule 65.
Rule 65, Lord.
The Central Services Pension 2021. So, issue notice in terms of forms. So, since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week. Yes.
And by the specifying the second case, I am also applying for interest. And so far the share of pension will be paid money. Only interest will be paid.
Then here notices are issued.
No, minor.
Huh?
Affidavit file and it's a old matter, Lordship. Affidavit file, in fact, Lordship, we have placed
Then this item number 7, WPC so and so be listed with along with WPC is item number 6 after the returnable date, on the returnable date.
Case relates to the benefit of Upendas. Even last session, we have directed to complete the appointing authority hospital management. That's why we have
Yes,
filed
Borderland.
interlocutory application.
Verify,
Lordship,
verify and if eligible pay. There's some IA.
I am for completing the hospital management authority. The main petition hospital management. Appointed by the hospital
Then how can the BTC verify?
the parent authority.
Are you pressing your IA or not? Heard council of party. Any objections in the IA? No objections. Any objections in implement?
No.
Heard. IA can be given. 1713, the application has been filed seeking implement of the Hospital Management Committee, Thalmara Primary Health Center. And this 1 to 7.
1.
1 to 7. Oh, okay. opposite party, as party respondents in WPC 1388 of 2026. The BTC Council does not object to the prayer made. And the State Council, the Standing Council for Health, as also the Finance, has no objections to the prayer for implements of such circumstances without issuing notice. At this stage, this court is inclined to allow the IE. The opposite parties number so and so. The array is from respondent number 7 onwards. IE is allowed. Amended course title will be filed within 2 weeks from today before the registry. The writ petition, right, in view of the order passed in the IE of the parties so and so in the IE are arrayed as respondents 7 onwards. The petitioner will file amended course title before the registry, and the matter will be listed thereafter.
Lordship, after amendment, a copy may be given.
The amended course title be filed before the registry should also be furnished to the respective council appearing for the respondents.
9
and 10 similar. 9 and 10 similar. So the IE as a yes.
Lordship, kindly pass over for time. I had some pending in another.
That is not a ground for adjournment.
No, Lordship, time being, Lordship.
Typing also not permissible. Why should we upset our routine, our record? You are there, you argue the matter. It's a question of promotion. Notice issued.
No.
Last date also it was adjourned on the ground of inconvenience. Please inform your senior.
Petitioner, then the as per the complaint was lodged by the private respondent number 5, alleging that he took a loan of rupees 10 lakhs from him. From her, we have promised to return the same within 6 months, and but did not return. The complaint is made at page 21. Page 21 is the complaint. The deputy inspector general of police filing on the FIR against so-and-so. With reference to the subject cited above, I would like to draw your attention to the following matters. Srimati Ranu Sekhya, widow residing at the Borabari with my daughter.
All right, we'll issue notice today. Heard Mr. K. Sharma, counsel for the petition, and as MSB Sharma and CDC, he has an accepted notice on behalf of 1, 2, 3, 4.
Lordship.
Therefore, notices in respect of the official respondent are waived. Extra copies be furnished within 3 working days. Steps on respondent 5 and 6 by speed post within 1 week from today. That will be listed after the returnable date.
Yeah.
Interim after service, after return of service. Prayer for interim to be considered after return of service.
The petitioner was appointed as a master worker in the year 1989, and subsequently in 2005 his service was regularized. In 2011, Lordship, unfortunately he went missing, and in 2017 his wife, immediately in 2013, the department filed an FIR saying the missing status of the
How,
person.
where is the question of he going missing and coming back?
Lordship,
You are mentioning that he went to Punjab.
yes,
How
because he went to Haridwar, page number 3, para number 3.
Yeah.
I've explained.
No, you have explained, but he lost his memory.
And again,
He gained it in Haridwar,
no, in Punjab.
in
Because
Punjab.
he spent 7 years in Punjab. He was traveling to Haridwar, but was given some edible by some co-passengers. And then this incident taken place. Now the difficulty for the petitioner, lordship, the estranged wife of the petitioner, she filed an petition before this honorable court praying for family pension. This honorable court directed the respondents to grant family pension. The PPO was also issued. And in the meantime, when she was asked to appear before a treasury officer, the petitioner appeared. And therefore, she did not go to the treasury officer. And after 2-3 years, that is in 2023, the wife of the petitioner eloped with someone else. And now she is living separately with her new husband. And in fact, out of their wedlock, a female child was born to them. And now the petitioner is in difficulty because he cannot receive his pension, which was allowed to his estranged wife, because it's a family
You
pension.
have to file an application before the court which had passed the earlier order. This FPPO is in deference to the order passed by the court.
Yes. The difficulty for him is that, lordship, he cannot receive the money because it's a
No,
family
receiving
pension.
money will come later, but you need to correct this order. You'll have to bring these facts before the court which had passed this order.
Then review applications.
We don't know what. There is an order passed by the court.
I have just challenged the order later dated 18/7/2019, whereby the PPO was issued.
There is a direction
Yes.
to the respondent one to resubmit
Yes.
pensioner's paper to the accountant general along with the police report.
Yes.
That's all. So therefore it was sent.
In terms of that order, it was.
It is not that they have done it on their own.
Yes.
It is pursuant to an order passed by the court.
Yes.
This order will have to be corrected.
But there is another player also. In 2019, he returned. He filed an application before the DIMAS or DIMAS Council, the Executive Engineer PWD Road Division.
So in the face of an order of the court, what orders can the authorities pass? This order will stand. This order stands.
Lordship may give me liberty to withdraw it and file an appropriate.
Counsel for the petitioner seeks liberty to withdraw the writ petition and file appropriate application before the courts in view of an earlier order dated 2009-2017, passed in WPC 7617 of 2015, having been passed by coordinate bench. So, liberty prayed for is granted. The petition stands dismissed. As not pressed, anyone appearing for respondents? Hardhor appears for PWD. MS Sharma appears for Accountant General. And A. Bothakur for Finance.
I'm appearing for response number 2, 4, 5, and 6.
D. Kalita for Dimahasa appearing for respondents 2,
2, 4, 5, and 6.
2, 4, 5, and 6. Ardhor is for 1 and 3. Yes.
Proceed that his specific service of his good will employ, my lord.
But why a writ? Why not the labor court?
Yes, lordship.
Then, after some time.
Petitioner challenging the termination of service order, my lord. The page number 40. This is my lord. Notice.
Appeal. What about appeal?
Okay, he has submitted application prayer for 42 page number.
42.
Okay.
This is a prayer for reinstatement. Against the dismissal order, no appeal filed.
There is no provision for appeal for contractual.
Contractual. Where is the order of the appointing authority? I mean, the disciplinary authority?
Page 40.
Is the page 40.
Where is the inquiry conducted?
Inquiry conducted, but
Inquiry report?
report was not furnished to the petitioner.
Why report not furnished?
Lordship, although the rigors of Rule 9 doesn't apply to contractual workers, but there was
Basic
a
rules of Article 14?
Sorry.
Why conduct an inquiry if you don't want to disclose the reasons
No, Lordship,
for
a show
termination?
cause was issued, although with a copy of the preliminary inquiry which was submitted by the CU. That is at page 31 and 32, along with the show cause.
The show cause.
32 would be the place and includes a copy of the inquiry.
But on the
What inquiry?
There was a preliminary inquiry.
But after the show cause, was there any inquiry?
He submitted his reply after that, being not satisfied that final order has been passed.
There is an inquiry report submitted by the Chief Executive Officer.
Yes, no,
Page number 40, para, second para, rejected the inquiry. Submitted.
That has not been given.
Not.
No, this inquiry report which was furnished with the show cause, who conducted this inquiry?
This inquiry conducted by the department.
Commission.
Department law. So, course notice was issued by the assistant deputy.
It is submitted by the counsel for the petitioner that the inquiry conducted by the department in response to the show cause notice issued, dated 6/5/2024, pursuant to which inquiry the writ petitioner came to be terminated. For my copy of the inquiry report was never furnished. Mr. A. Ghosh, counsel for the respondents, will apprise the court as to the manner and the procedure which was undertaken for termination of the writ petition list after 2 weeks. Extra copies be furnished within 2 working days.
Right.
That's it, third round of litigation, brother. The petitioner was appointed prior to 1/4/1993 as master roll workers, brother. And you will achieve the earlier round of litigation, page 64. Observe that since the service book has been open and he has been working prior to 1/4/92, the direction was issued to consider his case. But the authority has rejected my case, page 72. Again, on the same ground that in terms of when the judgment, my case cannot be considered. I am receiving scale of pain and I will be retiring after 2 years. Shall be covered under the old pensions since I have been appointed in the year 1990.
File an appeal. Why have you not filed an appeal?
Not termination, regulation, regulation of service. And still continuing. Keeping order is page 72.
terms of your honorable court's order, lordship's order. Is 69.
No, court's order is enough. Once our court has passed, whichever court has passed an order, it must be complied with.
Is 72 on the same ground. They have rejected my case. One communication was placed dated 30/1/2024. That has been set aside by your lordship. On the basis of same ground, they have taken in same ground while rejecting my case.
Counsel for parties issued notice written about 4 weeks from Mr. R or appears in exception notice on behalf of all.
All manner. Yeah.
Paper notices the waived, extra copies be furnished within a period of 1 week. List after return.
Tendency shall not.
Not while, what is the point? They've already rejected it. Where is the question of pendency?
Reconsider. Reconsider.
If it is to be reconsidered, why we are issuing notice, we'll close it. We'll direct them. You want a direction for reconsideration. Then item. Yes,
This petition is regarding compassionate appointment.
compassionate. Is there a scheme under the bank?
Yes. My father was an employee of the respondent bank and he died in harness is 28/11/2018. And thereafter, my mother applied for FDCF payment because at that point of time there was no compassionate scheme. So the bank never released the FDCF.
You can, would you like a notice or you want to get instructions here?
No, I'll have filing affidavit.
I heard counsel for parties issued notice written. Counsel appearing for the bank accepts notice on
I am
behalf
for
of
1 to 5.
1 to 5. And who's there for central government? Who's there? Mr. A.K. Dotto appears on accepts notice on behalf of respondent number 6. List the matter, let the respondents complete their instructions and the matter be listed after the return of the
Public.
The extra copies be furnished within 3 working days.
It will be after some time my senior is next number 1.
After something.
Deeply blessed. Our names were not forwarded on 6/25 to 2026. It's a covered case, my lord. Your lordship's order is at page 186. And operative portion is at page 180.
Yes.
After verification.
Third counsel for parties disposed after verification of 186 order. Mr. A. Burwa for the petitioner and Mr. N. Chaudhary for the respondent PTC disposed.
Obliged. Diploma.
Right, please. But there was a departmental proceeding initiated against the petitioner. 24/4/2025. The subject matter of covering court. The restraint order operating before taking to the restraint order. It will kindly turn to.
What are you challenging here?
Here, my lord, because I took leave, I was called for inspection of documents in the DP and I took medical leave. And because taking medical leave, now, my lord, I have been suspended in another DP. So there is a restraint order operating here,
Where is the restraint order?
Annexure 1. Page 29, para 4.
What restraint order? Coercive measures not to be initiated.
Yes, my lord.
Ah.
Now, my lord, this order was passed on 13th, and on my lord 6th, they called me for inspection of documents in the earlier DP that your lordship will find at page 32. Annexure 3.
Yes.
Yes. Now, my lord, at Annexure 4, I submitted a medical leave application and paid for extension of time. Annexure 4, page 34. Litigant 6 to litigant 6. And I have amended the relevant prescriptions also. And at page 36, the type copy. Acute chronic lower backage and radiculopathy. And the advice was avoid massage, bending forward, lifting heavy object, weight, bed rest for 2 weeks or till symptoms subside. So this was done at my Lord Gauhati Medical College Hospital itself, wherein I am serving as the assistant professor of oncology. Now thereafter, because I submitted this application for medical leave, the lordship will kindly turn to page 38. Annexure 5. On 9/3/2026, in pursuance to letter dated so-and-so, received from the Joint Secretary to the Government of Assam, Medical Education and Research Department disclosed. A medical board is hereby constituted with the following doctors of Gauhati Medical College and Hospital to examine the petitioner and ascertain the present health status. Then on 6th, my lord, since my condition was not good, my lord, I again prayed for extension. And thereafter extension was granted by order dated 17/3/2026, page 40. Second paragraph from the top. The medical board will be held in the office chamber of Sri so Professor Orthopedics on 23/3/26 at 12 noon. Accordingly, on 23, my lord, I appeared before the medical board, and this is the report, my lord. The original copy is at page 42, type copy at page 41. The board examined me, and the chairperson of the board prescribed that to attend PMRT. PMRT means physical medication and rehabilitation training, for strengthening of exercise of back and core muscles allowed to resume. So the first observation, my lord, and the substantiate my stand that I was having backache and back problem. That's why this prescription was.
This is an OPD report, advisory.
No, the signatory is the, my lord, Dr. Tulsiram Das, the chairperson of that medical board.
The medical board report will be not like this. Why will it be given in a
But this,
OPD?
but they have given me this.
Anyway,
Then, my lord, the page 43, I've been suspended on 7/5/2026, third paragraph from the top.
you are under suspension now.
Yes, on 7/5/2026, this is the suspension order. Reason is the third paragraph from the top, my lord. Whereas as per clarification submitted by the Department of Orthopedics, which was forwarded by the Superintendent GMC Gauhati by letter dated 12/3/2026, it was mentioned that the medical advice was obtained through deceit, where the petitioner deliberately misrepresented his designation and impersonated as professor of the State Cancer Institute to influence and intimidate a junior postgraduate trainee, Sri so-and-so, who was on casual duty. I am employee of the GMC for last 18 years, my lord, as an assistant professor. Why should I impersonate, my lord? Now that's why I have
Which medical report?
My lord,
Which medical advice?
Yes, my lord, that
Page 42.
my lord, at page 35. and 36. The first medical leave, by which I applied for medical leave. 35 and 36. Appended to my medical leave application at page 34.
What is the advice?
Advice, my lord, at page, type copy at page 36, original is page 37.
So what is the advice? It is that-
2 weeks bed rest or till symptoms are.
Hmm.
Because they say that I have obtained this through deceit and coercion, intimidation. They were suspended. Now, on 7/5/2026, suspended, and on 8/5/2026, another DP initiated on the same ground that I have impersonated, obtained this medical advice under deceit, that you will also be find at page 45 and chapter 10. Now, my lord, the other two petitions. Initially, what happened, my lord, the petitioner was eligible for promotion to the post of associate professor oncology.
No, we'll issue notice here
Yes, Lordship, kindly issue notice.
if you want.
Yes, I want, my lord.
You want notice.
And my lord,
Yeah.
I want some protection also.
What protection?
My lord, because the other two cases are pending, and Lordship will kindly tag this matter with the.
That is a different issue, but the so-called restraint order that you are asking is only not to take coercive measures in respect of the departmental proceeding.
The alia, issued by 24.
How is it connected with this?
No, my
This
lord,
is a fresh
because it's an offshoot, because they are right to medical.
offshoot or not, we'll examine it. But is there a bar that you cannot have more than one DPs?
There is no bar. But
So
Lordship,
it is a matter of inquiry to find out whether there is any truth against the allegations against you.
the board's recommendation after examination, attend the PMRT, to strengthen your back, core muscles. That itself, my lord, substantiate point that I was using, my lord.
We'll examine that.
Nothing can be examined, but some protection.
What protection?
And there's
Protection to what extent?
no- To the extent that they will not take course.
What is the meaning of that? They've already taken according to you. How are you benefited by that order?
Nothing kindly see.
Are you suggesting that they should not proceed with the departmental proceedings?
Yes, that is not-
That we cannot do it. Why should there be a restraint?
Because, my lord,
How is it going to prejudice you?
because, my lord, if they proceed, my lord, everything is on record. The medical board examined. If I have, my lord, if there is any positive in my claim, the medical board.
That will be examined there. Where is the question of prejudice to be suffered when you are already facing a DP? It is not on the same issues. Is it on the same issues?
My lord, because I did medical leave for inspection of document.
That will examine it.
Medical board was kind of considering that.
Yes,
In the other case, the allegation is he was transferred from Cancer Institute, where this particular department is totally closed. He did not want to go, and that is one issue. But the main issue was that he was collecting all the patients from medical college and taking it to name care and other private hospitals. He was a regular supplier of patients to the private through the government institute. That is the allegation in the other case. And Lordship was pleased to that transfer case is also pending for 1.5 years, as well as the DP case also is pending now. So Lordship
transfer, there is a stay.
Yes, there's a stay, and I would like to file the application for early hearing. In fact, the other day when both the matters came up,
We'll connect all these matters.
all this
together.
connect, and Lordship will kindly issue notice. We'll file an affidavit in 2 days time. Let all the 3 matters come up next week, Lordship, either Thursday or Tuesday. Public interest is being suffering, and he is indulging in all these things. He's a nuisance to the medical institution.
We'll issue notice
He
today.
can go up to the extent of threatening pressure on the young doctors to get that certificate, and also impersonate him as the professor, where he is himself is saying that he's a assistant professor. And that particular department of whom he is claiming to be the professor, that department is no more in existence. So it's a very serious case for the whole medical institution.
Heard Mr. J. Patwari, counsel for petition. Mr. David Sakya, Advocate General, hearing for the state, assisted by MSP Burma for the respondents. The petitioner before this court is aggrieved by the impugned. Show cause. Suspension as well as show cause. Suspension dated 7/5/2026 and show cause dated 8/5/2026. Directing him, drawing up proceedings against him. Stop. It is submitted that petitioner had earlier approached this court by filing WPC 1084 of 2025, and where what was that?
My lord, in WPC 1084 transfer was second, and in WPC 4108 the earlier DP was.
This order passed in 13/3.
13 WPC 4108 of 2025.
4108
Yes, 4108 of 20.
and 1084 also.
1084 is connected because the transfer order was.
Yeah, there's a stay order is operating for last 1.5 years.
The filed two writ petitions, being WPC 1084 of 2025, where the transfer order of the petitioner was challenged, and WPC 4108 of 2025, where
the earlier DP
another proceeding initiated against the writ petitioner is under challenge, and this court, by order dated 13/3/2025, directed that no coercive measures be taken against the writ petitioner in respect of the departmental proceedings. They submitted that notwithstanding this interim order, the department has again proceeded to place him under suspension and draw up a fresh proceeding by issuance of the show cause. The counsel for the respondent submits that Ms. P. Burwa submits that instructions are not complete. She be permitted time to complete her instructions and file necessary affidavit
Within 3 days, Lord.
within a period of 1 week. Prayer made is allowed. Place this matter after 2 weeks. Let the pleadings be exchanged. Then we'll have to issue notice. We'll
Lord,
issue
they may
notice.
issue notice and
Then
take the other two
notice
cases also along.
returnable after 2 weeks. We listed along with WPC 1048 and 4108.
Order 2025. If a lordship is
2025.
pleased to give a date after 2 weeks. Maybe 11th, if it is not inconvenient. 11th of
It's the 11th. It will be a week after.
then 16th of June.
16th, all right.
Lord.
16th. Notice on the interim prayer also issued, returnable on 16th.
My prayer that Lordship may be pass a observation that all matter and endeavor will be made to dispose of
We are listing all the matters.
all that disposal that.
That's not necessary,
No.
but you are entitled to review the prayer for disposal.
Lordship.
Because
Because the transfer order, stay order is operating for 1.5 years. It is our fault also we should have filed a early hearing.
But
But we
we'll
are
take
not
up the
filing.
matters on the same day.
Deeply.
I think there's a
Yes.
My lord, I am sorry.
No, you don't have to be sorry, but you should allow your colleagues to address the court. They appear without a brief before the court. Yes.
My lord, what happened, my lord? In this case, the petitioner was appointed by Annexure 1 at page 22. As
No,
Inspector.
what is your prayer here?
my lord, what happened, my lord? The petitioner was at serial number 4 and serial number 6.
You are
and-
asking for promotion,
No, my lord.
giving you the benefit of seniority.
Seniority from date of my
Heard-
juniors were
Heard
promoted.
Mr. G. Postal and counsel petition, senior counsel appearing. By Mr. B. Sharma. B. Sharma. And Mr. B. Chaudhary appearing for all.
Yes, except one lordship.
Who's for 5?
1 and 5 lordship.
2, 3, 4. Mr. Ardhor for 1 and 5. Since the respondents are represented, notices are waived, extra copies will be furnished within a period of 1 week from today. This after the returnable date. Respondents may file their objections, affidavit.
Deeply.
Pending item 14.
Ever court has the jurisdiction, my lord.
None appears for the petitioner, even after the matter is called for the second time. MS MD Chaudhary, MD Bora appears for transport.
Lordship Corporation Department for
Corporation
Respondent 2, my lord.
Respondent number 2. Mr. CKS Bora for
Number 4.
respondent number 4. Please again next week.
Okay.
None appears for the petitioner in person when the matter is called up. None has appeared for the petitioner in person on 7/2/25, 9/6/25, 25/6/25. At view of the matter, this I stands dismissed on prosecution.
Lordship, in the morning I had seek for adjournment, your lordship. Lordship may record this as the last opportunity, lordship.
Who's for the petitioner?
Lordship, we had already informed the petitioner about not doing this matter in the morning. Your lordship.
Yeah.
It
What
would be
is
bad if
your-
the matter is dismissed.
Huh?
It would be bad for them if the matter is dismissed.
Be bad for everybody, but then question is, why are you seeking adjournments?
Lordship, some talks are going on.
No, we are relisting this matter next week. You come up and tell us whether you want to pursue it or not.
Lordship.
On the request made on behalf by the respondents, Mr.
A. Goswami.
A. Goswami, matter stands deferred to be listed again on 3rd of June. It is, it appears that the petitioners are attempting to resolve the matter out of court. And however, and therefore the matter has been adjourned on several dates. The status of the disputes between the parties, status of the matter being resolved out of court is not known or placed by the councils to the court. Placed again on 3rd.
Lordship.
So lordship, the nothing council is out of station for the petitioner, lordship.
This is an IA for what?
I for improvement, lordship. Applicants have filed for the improvement, lordship. We have already filed the objection, lordship. We have objection for improvement.
Request is made for accommodation on behalf of the arguing counsel, Mr.
R.S. Mishra.
R.S. Mishra, on the ground that he is out of station. Release the matter next week, 3rd June.
Okay.
I pray for a little accommodation.
Why?
That I may community become something.
Why?
My senior is coming.
Who is your senior?
Mr. S. Dr. Maila. We will argue this.
All right.
Oh.
This case has been filed for restoration of the reputation unit. It was dismissed on 29/4/2026. So on that day, there was a heavy rain, due to which we could not appear in the court,
How do we know there was heavy rain?
Lordship, we have given the photographs.
Photographs.
Yes, sir. Annexure 1, page 12.
Heavy rain on that day.
Yes, sir. It started around 7 o'clock.
That you did not mention. What is your writ petition about?
Lordship, it's for regularization or Lordship.
My lord, will peruse the order dated 29/4/26, that is Indian, my lord.
In the writ petition.
Writ petition, page 20, my lord. This is not only about that, my lord, was not present. Something else also is there.
What is that?
It's a very brief order, my lord.
You are referring to which order?
Page 20 of
Page 20 of the IA, my lord.
Page 20 of the IA.
Last page of the IA.
Last page.
Yes.
IN order dated 29/7/20.
Amended course title, not filed.
Lordship.
Not filed, yes, then, my lord.
Have you filed it?
Yes, your Lordship.
When?
Annexure 2, page 14, your Lordship. It has been reflected.
In the IA?
No, your Lordship. In the main case.
Ah.
It's on 28/4/2026, we have filed it. And on 29/4/2026, the petition was dismissed for non-prosecution. But the non-prosecution happened only because of the rainfall. We could not reach the court. And on the last occasion, my lord, if I may read, the petitioner did not appear in the last occasion also on 18/12/2025. But that order, page 17, there is no non-appearance recorded, and we were actually present on that day. Yes, Gautam, your Lordship.
Mr. S.
Gautam.
Gautam, counsel for the petitioner, and Mr. R. for appearing for the party. This is in the IA. The IA and Mr.
Respondent field, L. Sangam.
L. Sangnam for respondent number 3. This IA has been filed, seeking recall of the order dated 29/4/2026, whereby the writ petitions to dismiss from prosecution. Counsel for the petition submits that on the day when the order was passed, which is 29/4/2026, the city was reeling under heavy flood due to rainfall, heavy rainfall. Stoppy has enclosed copies of news reports. Yeah. Stop. Further submits that the imbued order, in the order sought to be recalled, there is a further observation that the amended course title has not been filed with the petitioner for about 2 years. Stockey submits that the same is incorrect, as the amended course title is already available, filed before the court on 27/4/2026, and was submitted on 27/4/2026, and is shown to be filed on 28/4/2026. So, under such circumstances, we learn at counsel for the petitioner submits that the issues involved in the writ petition pertain to the claims for regularization.
No, your Lordship, pay parity, your Lordship.
Pay parity. And because it still survives, but because of the grounds urged in the IA, the counsel engaged with the petitioner could not appear before the court, and as a consequence thereof, the matter is dismissed from prosecution panel. Mr. Ardhor and Mr. Santam does not object. You object or you not?
Well, I'm leaving it to Lordship.
No, do you object to the fact that there was no raid?
That, my lord,
Counsel for the respondents do not object to the submissions made. And the such circumstances, this court is of the view that the IA should be allowed at this stage without issuing notice. Accordingly, the IA stands allowed. No prejudice will be caused to the respondents as they are already represented in the petition. So IA stands allowed. Order dated 29/4/2026 stands recalled. The petition restored to file. Matter be listed in the month of July on a date be fixed by the registry.
Thank you, Lordship.
Yeah, please, your Lordship. Lordship, as per office note dated 22/5/2026, neither ID card nor answer notice has been returned by your Lord. Services awaited, your Lordship.
As per office note, service is awaited. In respect of the sole respondent, matter be listed again. Therefore, matter be listed again after 4 weeks.
Lordship, in item number 24 as well as same office note reflects that neither ID card nor answer not.
Same one.
Much obliged.
An increasing application in a contempt matter, my lord, the former contender having conferred, the new incumbent enjoined. And you have also contacted him, my lord, for submitting presentation. But he is not taking steps. So his equipment is required.
It is submitted by the counsel for the petitioner. I agree that the earlier incumbent was arrayed the respondent number 1, sole respondent in the contempt petition, being contempt case number so and so, since debited office, and the present opposite party is now the managing director of the state, Assam State Warehousing Corporation. Stop, and since the directions contained in the order dated 3/3/23 passed in WBC 5093 of 2022 has not been complied with as on date. The present incumbent of this Assam State Warehousing Corporation is also required to be arrayed as a party. Anyone for the respondent here?
Even the appeal.
Considering the submissions made at this stage without issuing notice, the IA stands allowed. Opposite party arrayed in the IA is directed to be impleaded as party respondent number 2 in the contempt petition number so and so. Amended course title be filed before the registry within 1 week from today. IA accordingly stands allowed. Disposed of the contempt petition will write in view of the order passed in the IA, so and so is arrayed as respondent number 2. Petitioner, the contempt petitioner will file amended course title within a period of 1 week from today. Matter be listed thereafter by the registry.
Much obliged.
I'm sorry, my lord, item number 25 and 26, my lord. I am in 26, but that has been mentioned by someone, my lord, but without informing me. And my lord, my prayer is even the matter is otherwise infractuous. So even Lordship will fix a date, my lord, instead of 3 weeks, my lord.
Someone from APDCL had mentioned.
Yes, well, without informing us. Well, otherwise, matter is infractious, madam.
You bring you the APDCL council will pass orders.
It will be difficult. Only one to fix the date, madam.
That also is again without informing the other side.
I will inform, madam.
You get the APDCL council, whoever is there, will fix a date, or you make a mention separately. By way of a mention memo, we fix it.
I'll try one if it's possible.
Sorry, Lordship, for item number 20, Lordship, we have some difficulties on 3.6. For item
You have already passed notice. You make your mention when the matter is listed next day.
I is for implement, Malad. What has happened in this case, Malad? Here, I am a direct recruitment diploma holder. During my service, I acquired a degree, engineering degree. I was promoted. Now, as per the rules, though it is a promotion, it is to be treated as a direct recruit. In the meantime, some of the direct recruits, other direct recruits were appointed. Now, inadvertently, what happened, my lord, in the writ petition, we have mentioned, referred to the respondents as private respondents, but they were not implicated.
Right.
This is
Any
an
objections, Mr.
My
Lord?
lord, one difficulty, my lord. My lord will come to page number 3.
Address.
My lord,
address is not
nothing, my lord. Only the name, my lord. It will become, my lord.
How do you propose to serve copies?
How do we
My
serve, my
lord,
lord?
they are 2003 batch appointees, my lord. The department will definitely know, my lord, where they are
You
posted.
make an apply. You apply to the department. Get the addresses.
My lord, cause nothing is there, only names. It will become very difficult for
Why
us.
My lord, they can take step, my lord. They can
Why
lead us, my lord.
This is not our case, my
No,
lord.
why
This-
should they be saddled
This is
with
their
the
case.
responsibility of serving copies, filing affidavit?
At least,
Get
my
the
lord,
details.
let this be pending, my lord.
Ah.
Let my learned friend at least
No.
try and get the
No,
instruction.
you,
My lord, I have
you
many
approach
works.
the department
My lord.
with a request that kindly give me the list of dates of places of posting.
Your lordship will make the kindly clarify that.
In the IA, this is an application seeking implement of respondents 5 to
175.
175 were direct recruit appointees
Appointees of the year 2003.
of the year 2003 to the post of
Junior engineer, not
Junior
junior engineer.
junior engineer.
Assistant engineer.
Huh?
Assistant engineer. Assistant engineer.
Assistant engineer and are posted in several and as assistant engineer. Stop. Petitioner in the accompanying petition with WPC so and so has raised the issue of seniority
Seniority.
vis-a-vis the private respondents. So, however, their present places of posting are not known. Petitioner applicant is permitted to approach the office of who will give
Commissioner
the
and special secretary.
office of the Commissioner and Special Secretary, Government of Assam, PWD. Is there a PWD road and PWD
be
separate
roads, ma'am.
commissioner?
It will be roads.
Separate manner.
PWD roads.
Roads.
Seeking the particulars of the places of posting for these proposed for the persons at opposite parties 7 to 175.
5 to 175.
5 to 175. So, if any such application is made, respondents will furnish the particulars. The petition
I'm aware.
is after 3 weeks.
Similar matter has been.
Yes.
Lordship, their pending matters are there, Lordship, and in this IA, he is asking for amendment of the prayers. Petition of prayers for declaring the act to be ultra-virus or to modify the act.
Where are the prayers?
Additional prayer, my lord, that is paragraph 4, my lord.
Should notice it. Third, counsel for participation notice. Returnable 3 weeks. Mr. B. Chaudhary, counsel represents the respondents.
For respondent number 5, yes.
Respondent 5.
Yes.
Mr. D. Upamanyu for
Respondent number 4, 7 and 8.
4, 7, 8. MS. Yes, for respondent number 3. And 6. Respondent 3 and 6. Mr. D. Bora for 1. Respondent opposite party. Opposite parties will be presented. This is a way that extra copy will be furnished within a period of 120 days. Objections, if any, may be filed by the opposite party respondents list after the return.
Honest.
My lord, this I is for correction of applicable error in the prayer portion. The impugned dates. Page 16.
Page
1-6. Prayer portion
1-6.
of my writ petition.
Huh?
Prayer portion of my writ petition, my lord.
Prayer portion of your writ petition.
My lord.
Is it reflected in the IA?
Yes, my lord.
Where is it?
Page 6, my lord. Actually, my lord, my impugned order should be 22/7/2022. Yes, my lord, but it has been wrongly typed as 22/7/2022.
There is an interim order.
No.
No interim order. Any objection? Third, counsel IA has been filed seeking amendment of the prayers reflected in para 2 of the IA. According to the applicant, counsel for the applicant, the date recorded in the prayer portion of the writ petition, dates recorded in the writ petition, dates were wrongly recorded in the writ petition, and the same is sought to be now corrected. And as a consequence, this IA has been filed. Mr. S.K. Medi, Learned CGC, does not object to prayer made. Accordingly, this IA stands allowed. Petitioners are permitted to make necessary corrections by filing an amended writ petition. So once the amended writ petition is filed, copies thereof shall be served on the respondents. I allow disposed of in the writ petition. You write in view of the IA order dated so and so. I allow prayer for amendment is permitted. Petitioner will file amended writ petition within 4 weeks. Copies thereof shall be served on the opposite party respondents. I set up the line that perusal of the prayer upon perusal of the pleadings in the IA, also upon hearing the submissions, we will see that the amendment, if allowed, will not change the nature of the petition. Therefore, it's permitted.
This case, we have filed our affidavit yesterday, Your Lordship. Copy has been served.
Matter may be possible for time being.
Are you filing reply?
Yes, my lord.
You are filing a reply.
No, Lordship. Yesterday, we have filed our affidavit of opposition, Lordship. That is perhaps not in record also.
My lord, 1 week time may be granted.
Huh?
1 week time may be granted. I will
It
file-
is submitted by the respondent, Mr. DJ Das, that the affidavit in opposition has been filed yesterday.
Yesterday.
Stop. The said affidavit, however, is not placed, not connected to the case record. Stop registry is directed to registry will trace out the affidavit stated to be filed yesterday by the respondent and connect the same to the case record. matter be listed after 3 weeks, by which time the writ petitioner may file their rejoinder if any.
Much of
Why not with the promotion matter, non-communication of ECR matter? 2024 matter, why not, but affidavit in opposition has not yet filed. Who's for the respondent here? Mr. C. Bora, my lord, has accepted the release. Notice in the matter was issued on 9/12/2024, where Mr. D.C. Bora Leonard CGC had entered appearances, but not available in court. Therefore, the respondents are permitted 3 weeks further time, complete their instructions and file necessary affidavit, if any. Copy of this order be marked with the office of the learned DSGI. Matter be listed thereafter. If you don't. Kumar for me.
So over here, also the grievance of the petitioner is that although he rendered the Anganwadi worker, lordship, that service period is not recognized for entitlement of pension, lordship, that the old pension scheme. Initially, he was appointed in 1985. Thereafter, after completion of 10 years, he has been promoted in 2014, and thereafter he retired in the year 2022. And in similarly situated, facts and circumstances, this honorable court has taken note and passed the order that lordship will find at page 39 and except 12.
So during your service,
Lordship,
after your regularization,
lordship,
was there any deduction made?
no. They're saying that my service is now, lordship, recognized under the NPS scheme, lordship, instead of old pension scheme.
So if it is NPS, then some deduction will have to be made.
But there is no such any order, lordship.
Yes, respondent.
Lordship, we have done our affidavit. Lordship, we have received instruction that affidavit is yet to be filed.
So find it.
No, Lordship.
So recently also in similarly situated case, this honorable court has passed an order on lordship 20 May 2026. Generally same lordship, same assiduous project. She rendered more than 37 years of service. So in terms of the earlier order, lordship, direction is given to consider the case.
Where is the order of the court in WPC 2964?
Yes, page 40, lordship. Starts from page 39, 23rd of March 2020.
This is WPC 1999. WPC 2964. There was one order relied.
23rd pass in WC 1999.
No, that we have.
Yes,
but
sir.
in that order, there is a further reference of WPC 2964. Where is that order?
So, while this order was issued, lordship, at page 39, in this order, lordship, that order was relied upon.
That's what we want to see. What is that
But
order?
I'll
What is that order?
let's do. Fine.
Counsel for the petitioner submits that this claim of the writ petitioner that the services rendered as Anganwadi worker
Worker, Lordship.
for more than 30 years.
37 years.
37 for about 37 years has not been taken into account while considering our pensionary benefits. Is the claim of the petitioner that the case of the petitioner that the petitioner would be covered, would be entitled for pension under the old pension rules, considering the number of years of service rendered by the petitioner. So, counsel for the petitioner has placed reliance on the order dated 23/3/2020, passed in WPC 1999 of 2022 and order dated 2005/2026, passed in WPC 7299 of 2025. Submit that the writ petition, present writ petitioner is also similarly situated and the petition can be disposed of in terms of the same orders. Better. Ms. Kemprai, on the other end, submits that instructions have been received and she would like to file their affidavit. Better. Having heard the counsel for the parties and upon perusal of the order passed by the coordinate benches, it is seen that there is a reference to an order passed on 28/6/2019, passed in WPC 2964 of 2018, and the directions in that order stood extracted in the order dated 23/3/2022, passed in WPC 1999 of 2022. Stop. Counsel for the petitioner seeks liberty of the court to place the said order before the court on the next date. Considering the prayers made, placed again after 2 weeks.
So date will be fixed. So 2 weeks any date.
17th.
Sure.
17th of June.
Development.
If we do lordship, we need some time to obtain our instruction.
My lords, this
Objections
is
have not been filed.
That's right, my lords. And this is a case, my lords, where the railways has sought waiver under 12.5 from the contractor that has been denied. Then they have gone on to act on the arbitration clause, seeking appointment from a panel of arbitrators, which is squarely, my lords, governed by the judgment of core.
Is it the tribunal is still functioning?
No, the tribunal has not been constituted. My learned friend's client has lost the right to appoint. They still have exercised that right and tried to appoint. That appointment also is illegal because it's
All right.
hit by the judgment of
How
court.
long will you take to file your response?
6 hours.
2 weeks. All right. MS so-and-so appears for the petitioner, virtual mode, and MS so-and-so appears for the respondent, and needs a prayer for further time as it is submitted that instructions have not yet been received. She submits that 2 weeks further time be granted. Considering the issues involved, this matter again after 3 weeks.
Obliged, my lords.
Is there any date we fixed on the earlier matter?
No, my lords. My lords has said 4 weeks returnable. But for this, if my lords will appoint, because my lords, technically this is one set of 8 arbitrations.
Make it 2
And I'm in
weeks
the process
based on
of
17th. We'll have it on 17th of June.
Obliged, my lords.
17th.
Okay.
Yes.
The prisoner before lordship, he was a recent SP crime Hojai man, and he was placed under suspension minor on 11th of September 2025. But no, there was no review meeting, my lord, no disciplinary proceeding, nothing has been done. Just kept pending.
He was
Already more than
placed
90
under
days.
suspension on
11/9/2025, lecture 5, page 22.
but no proceedings have been
Nothing has been done, no review meeting, everything, nothing was done.
Yes, Mr. Bora.
Your lordship, instructions are still awaited. Time may be granted at least
2
1 week.
weeks, 2 weeks, not beyond that.
Yes.
So Naudhar Chaudhary case, the 90 days, beyond 90 days, they cannot do anything.
The Mr. P. Kotoki, learned senior counsel, assisted by MS A. Lala. And Mr. Bora, D. Bora, will for the respondents. Mr. Bora renews his prayer for the time. As instructions, as it is submitted, that instructions have not been received. Mr. Kotoki on the other end submits that the writ petitioner was placed under suspension on 11/9/25, and thereafter he continues to be under suspension. Stop. The authorities have not initiated any meeting for review of extension of suspension, nor any proceedings, departmental proceedings have been initiated. Where is the suspension order?
The page, Annexa 5, page 22. Persons to an FIR, it was.
And no disciplinary proceedings have also been initiated. Under such circumstances, petition is before the court, and it is submitted that the actions of the respondent in keeping the petitioner under suspension is violating of the judgment of the apex court rendered in Ajay Kumar Chowdhury, reported in so and so. Considering the submissions made, the matter be deferred to be listed again after 2 weeks, enabling the respondents to complete their instructions. 19th June.
Highly obliged.
From service, appeal, appeal. I am before you.
Will issue rule. All for the records, matters should be listed for hearing.
That way, my lord, the lordship may give that indulgence of placing my case in the admission column with their affidavit coming. May take a long time, my lord, because your lordship may, there was the expensive, there was no evidence, nothing was there.
What about the appeal and all? Dismissed. Mr. P. K. Roy Chaudhary, learned senior counsel, assisted by MS R. Roy. Appears for the petitioner. Mr. S. Dr. Standing Counsel Revenue appears for the respondents. The counsel for the respondent reduces prayer for further time, and it is submitted with instructions have not yet been completed. MSN Bhattacharya, State Counsel, appears for respondent number 3. This matter, let it come in July then. July?
Last end of June. Last end of June.
End of June will not be available for admission here. Perhaps. As per precedence. So, early part of July? 16th July. Immediately after the opening for admission.
Problem.
Timing again 21.
Yes.
Well, there was an order for filing an additional affidavit. Bring on record the particulars of the employees, my lord, had come to the petitioner, to the respondent department. But that affidavit was filed.
In the IA?
No, my lord, in the writ petition itself. 29th of April, my lord, the affidavit was filed. Perhaps, my lord, it's been tagged with the record. There, your lordships will file. Paragraph 2, my lord, I have indicated.
Affidavit in reply.
Oh, my lord, it's an additional affidavit.
Filed by the petitioner.
Filed by the petitioners. Your lordships are directed to furnish information about their status as to from which department they have come and in which post they have been working. So, in pursuance thereof, my lord, it has been filed.
7 February.
No, my lord, it's thereafter 29th April.
Yes.
There in page 2, paragraph just below paragraph 2, my lord, the table has been produced. So in that table, your lordship will find the details of the persons, and most of the petitioners have by now retired, except for the petitioner number.
Your claim is that you want the benefit of the pay commission.
Pay commission, yes.
Ah.
And which at one point of time they had given. But subsequently they have stopped it on the ground that in the revised pay rules, the particular posts and the departments that have not been mentioned. It has been all along their practice, right from
You
the
are
time
employees of a corporation.
corporation. And the corporation was created without bifurcating the, so to say, a branch of the department and creating it as a society initially. All the persons were drawn initially from the department. They were put in the
They were on deputation initially.
no, it was initially maybe, Miller, it was long back 85, 86. Maybe initially they were on deputation. But thereafter also the persons were being drawn from there, from the department. And therefore, right from the beginning, it has been the practice of the government that whenever there is a revision of pay, so since they came with the pay being protected, their past pay being protected.
So where are these orders? Where is the order that you are being posted at this society with your pay being protected?
No, for the present petitioners, Miller, it will not be here because these petitioners were appointed
by the corporation.
Corporation some of them were from the department.
See, but the core issue is whether you are otherwise entitled for pay revision per se.
Yes, per se. I mean,
if the pay revision, if the pay commission has not, it is meant for government employees.
Yes.
Now, is your status that of a government employee?
Strictly speaking, no. Strictly speaking, it is not.
If you are being brought to the corporation under pay protection, then perhaps you can get some benefit.
Yes.
If you are on deputation, certainly you get your benefit. But if you are an employee per se of the corporation, unless the corporation accepts that no, we will also give the pay benefit.
Now the corporation runs entirely on the funds given by the
Therefore, it is
state.
the policy decision of the government to decide whether to give you or not to give you.
Yes. Now, all along, Lord, from 1985, the government has always been providing us the benefits of the pay. And whenever there was a hike in the pay structure of the government, Lord, corresponding hike was also made in the pay of the corporation.
But that is a policy taken by the government. Whether is there a bar for the government to go back to its back?
Well, here the government as such has not taken a decision not to grant us the benefit. It is the finance department who is coming in between. Because all along, Lord, the government, whenever there was a hike in the department, in the past pay revisions were also, Lord, the corresponding revisions were granted to us, and the finance department had also passed on those claims.
You'll have to support your case by some precedent. Otherwise, prima facie, where is the right to seek for a mandamus?
Now, if it is a case of granting aid, my lord, and if as the petitioners have stated here that the entire structure, entire corporation runs on the grant supported by the.
Therefore, all the more reason why you should not ask for pay hike.
No, that is the.
If it is a case for grant of salary, not being paid is a different issue. You are asking for pay hike at par with the government officers. You are not a government officer. You are asking the benefit of pay revision because at some point in time it was granted.
No, it not some point of time. It has always been granted because the initial, the employees were drawn from the department, agriculture department. So they came with their pay protected, and they were always being granted.
So therefore, we are asking: is there any order to show that the employees have also been brought in from the agriculture department, all benefits, including pay protection? Then we have a case. But as a employee of the corporation, simplicity.
In that case, I'll produce the pay revisions of the past years. The pay revisions will include
pay revisions of the past year. We are not disbelieving that. We are saying that if some level, the government decides that no further pay revision, does it give you
If
an
it is a,
accrued right?
my lord, my submission is this: if the government decides it, that as a matter of policy, regardless of the past practice, will not do.
That's
My
a
lord,
part of the government.
but no, my lord,
Where is that order rejecting your claim?
no, my lord, it is the only final. The agricultural department has also always been saying that we should get it, but it is the finance department who is raising a very technical claim, my lord.
Where is that?
It is in the repetition. Your lordship will find it is in annexure 85.
85. Who's for finance here?
Finance.
They have filed an affidavit.
They have filed an affidavit. And their only claim is that in the ROP rules 2017, the name of the corporation has not been mentioned and the employees of the corporations have not been indicated, and that's why they cannot give it.
When is the next proposal? Likely.
Likely, it will be since it was this was with regard to the pay revision in 2017. And at present, they have been paying us.
This does not appear to be an objection, technical objection. You are not recommended, they have not given you.
So that is the technique, because in the ROP rules, what happens in the ROP rules, the allocations are indicated, and the departments are also indicated. They say that since in the recommendation it was not there, so we cannot give it. And it is an interdepartmental correspondence from secretary from the secretary in the agriculture department to the director. Director agriculture.
Is there any recommendation in respect of other public sector undertaking in the ROP?
That I'll have to check.
You have to satisfy the court that there is an accrued right, and you are required to be given the pay protection as was done earlier, or as have been accepted by the department.
Well, then I'll try to get the sixth pay recommendations of the sixth pay commission. In fact, they have been paying us in terms of the sixth pay commission recommendation. And the sixth pay recommendation your lordship takes into consideration, then it will appear crystal clear that this objection is just a technical objection. On their own, they have been providing us, because even seventh pay commission they paid us.
That. Mr. Borpujari, is there any practice of releasing the pay benefits in respect of public sector undertaking?
Because there is a specific exception carved out in the ROP rules itself. That the ROP rules does not extend to public undertakings or public bodies unless and until those have been specifically adopted with the concurrence of the government.
Adopted by whom?
Adopted by the public sector undertaking concerned with the concurrence and approval of the government, more particularly that of the finance department.
But you are not allowing them to adopt. They have adopted. You are saying that their reference is not there. Therefore, they are rejected.
Yes. So, merely unilateral adoption will not do. It will have to have a ratification from the government.
That's right. But you are rejecting it on the ground at page 85 that their reference is not there in the ROP.
Yes, reference is not there.
But your submission is, even if it is not there, if it is adopted by the concerned public sector undertaking,
A public sector undertaking, my lord, with all the financial implications parameters. They will have to lay down all the parameters before the government to take a decision, final decision.
No. Which appropriate authority in the government takes a decision?
My lord, first of all, my lord, the administrative department concerned.
They have already taken a decision.
Yes, now, my lord, so far as this concurrence of the finance is concerned, my lord, all the parameters will have to be satisfied. Merely saying that, my lord, it has been adopted will not do.
No. Your rejection letter does not raise all these issues. Your letter at page 85 merely says that there is no proposal for extending the benefit.
Yes.
It's mentioned in the ROP.
So
Therefore, they are rejected.
Yes, so therefore there has to be some proposal forthcoming, my lord, from the public undertaking or the public entity concerned. And that has to be, my lord, fructified by a concrete decision of the government. If I may draw, my lord,
from the department,
Which
the
authority in
recommendation
the
was
government
already
takes that call?
my lord, two authorities will be involved, my lord. First, the administrative department.
They have already taken a
Yes,
decision.
then, my lord, the finance department. Now, finance department has already rejected, my lord.
So we are asking you are rejecting it not because they don't fulfill the parameters. They are rejecting because their names are not there or
Yes.
they were not recommended.
Yes, my lord.
Now, but if it is the ROP, if it is it's a principle followed in the ROP that they are not to be extended to public sector, then their names will never be recommended. But if the authority, the public sector decide to adopt it,
Therefore, it has to be laid down, my lord, before the concerned pay commission. Here at page 84, lordship will find that the pay commission itself has not made any recommendation. Now, the expert body is the pay commission, my lord.
your submissions contradict. Either you say that no, it must be laid down in the pay commission.
Yes.
Unless laid down, nothing there. But if you say that the pay commission otherwise is not applicable to public sector undertaking, then there is no scope for
Yes.
the pay commission to or the authority to place these before the authority.
Yes.
But if the authorities are otherwise empowered, because they are public sector, they are empowered to accept the pay benefits. They may decide that we will enhance the pay.
Therefore, it all depends on, my lord, how at the end of the day, my lord, who is going to take the financial burden.
Who is going to take that?
Yes, here, if at all, my lord, that pay, my lord, pay structure is adopted, then here, my lord, the agency will have to take a call, my lord.
Agency has already taken a call.
No, my lord, they will have to.
All right, you get the pay benefit, the benefits which were earlier conferred. Matter be listed for, let it be listed for hearing. Why are we having it in admission?
Now that the pleadings are complete.
Pleadings are complete in the matter, issue would matter be listed for hearing in the month of August. Mr. S. Doctor, Senior Counsel, assisted by Mr. So-and-so for Petitioner, R. Borpudari for Finance, B. Chaudhary for Agriculture Department. Yes.
Okay. And so,
adding that seniority list minor combined selection. After question record for now, my lord. Kindly have a look at.
Yes, records are available. So what do they say?
Basically, two vacancies arose earlier and the next two vacancies arose next month. But they
by two advertisements.
But they have not given in the records. Nothing could actually come out as to why they have taken two different selection process and merged into one, and they came out with one merit list. That is not basically discernible from the records.
If it is not discernible, we'll have to interfere.
That is not there. The logic is not there. I try to find a logic as to why they could actually merge two selection process and came out with one single merit list.
because the two selection process were totally different. The merit, the written test, everything was different. But I don't know why no explanation could be actually found in any of the communications or thing.
My lord, advertisement, my lord. Selection procedure, last part, my lord. Those who are qualified in
Page number.
page 114 of my additional affidavit.
114.
My
There is no 114. 114. Yes.
my lord. Last, those who are qualified in
114. Para 7.
my lord, selection procedure, last. This is connection L, my lord.
Yes.
D, my lord, selection, last part, my lord. Those who are qualified, practical test will be called for oral treatment. The final merit list will be prepared on the basis of marks obtained in written test, practical test, and oral. Now, my lord, there is no mention that both the
This is the first advertisement.
This is the second advertisement. Similarly, my lord, first advertisement at page number, lordship.
You appeared in first or second?
First, my first.
First. This is the second
Second
advertisement.
Page 106 is the first advertisement. Similar sorts of clause, my lord. Last, my lord. Those who are qualified in practical test will call for oral interview. The final merit list will be prepared on the basis of marks obtained in written, practical, and oral.
Give us the records. What about respondents? Anything to submit? Private respondents?
Lordship, I appear for respondent number 4 and 5 in item 7. Lordship, my submission is nothing turns on two selection process and two advertisements. It is undisputed. There was one advertisement which appointed the petitioners. Thereafter, there was another advertisement that selected us. That selection, theirs and us, did not automatically culminated in an appointment. There's a difference between recruited and appointed, and that is established. The issue now is seniority is to be counted as the petitioners condemned in paragraph 5 of their writ petition from the date of initiation of recruitment, or should it be from the date of appointment? That is the narrow compass in my humble submission.
No, the issue is, should there be a segregation of should there be a combined seniority list for two separate processes undertaken by issuance of two separate appointment advertisements? Two separate selection processes.
Yes, Your Lordship. I have not been able to come across anything that says that is wrong in law. It's a matter of exigency.
But you must come up with something which says it is right in law.
Lordship, it is right in law because at the end of it, what is the argument that is made in N. Parmar? That my recruitment process began before.
No.
It goes back to date of vacancy. Lordship, they test this. What happened? The reason why.
The question is not that. We understand what you're trying to say, that you can't claim seniority before you are born in service,
correct,
etc.
Your Lordship is aware.
That is not the issue.
Yes,
the issue is whether the authorities have gone wrong by combining it. Because hypothetically, had the first advertisement seniority list, had appointments being made on the basis of seniority, perhaps the petitioner would have been senior in service.
My humble submission is no. Nothing turns on it. Lordship, can you take a look at page 89, the rules?
89.
Yes. That is my humble submission. Nothing turns on this. On there being,
what is clear from the advertisement, I'm not privy to the record, is vacancy arose perhaps. And as a
Page
matter
number?
of exigency, page 89 is the rules. And this is what governs this recruitment. It's a 309, Article 309 rule. It's called the Assam, page 90, Your Lordship. Assam Ministerial District Establishment Service Rules, 1969. And Lordship, the post is Rule 3, 6, Lower Division Assistant. And Lordship may now go to page 93, 6. Its recruitment is clause 6 at page 91, and subclause 6 of that pertains to lower division assistant.
Subclause?
Now, Lordship may kindly go to this. There's a note which contemplates a list. At the beginning of each calendar year, the Deputy Commissioner shall call for applications to fill up temporary vacancies of any kind which are likely to occur in the course of the year, in their respective establishments. On receipt of applications by a specific date, a test shall be held and a list of all candidates suitable for appointment to the post of lower division assistant shall be prepared in order of merit by the Deputy Commissioner. The list shall remain valid for 1 year unless it's exhausted earlier, and one such list shall be prepared every year.
Was there one merit list or two merit lists?
Now, Lordship, there's only one. They contemplate a list.
No,
So
no, in
at the
this-
moment, there's only one merit list.
No, in this particular advertisement, two advertisements. Was there one merit list or?
One merit list.
One merit list.
Yes, Lordship, I'll show you, Lordship. Lordship, page 93, and I'll show you what happened. Page 95 now. Page 95 is seniority.
Yes.
Subclause 11. In the lower division, the seniority shall be according to the date of appointment. Now, Lordship, is page 96, second paragraph. This is what relates to us, which is why I submit nothing turns on two different processes. When, however, more than one person are appointed on the same date, their inter se seniority shall be determined according to their position in the merit list prepared by the Deputy Commissioner mentioned in note 6. So, if you're appointed on the same date, your seniority will be on the merit list. Now, Lordship, what happens is, the first thing that happens is page 81. We both are appointed on 1st of March 2016, pursuant to two different recruitment process, but we are appointed on 1st of March 2016. Now, Lordship, what happens is page 81.
Yes.
This is the notice that they come up with. There is no list.
One.
It's in the additional affidavit in opposition. Annexure A.
Not the writ petition.
Not the writ petition. After the writ petition ends at page 49.
81 is the notice.
Yes, Your Lordship.
26 February.
Yes, Your Lordship. So this is the notice that they come out with after the recruitment processes. It is for general information. Yes. It is for general information for the candidates appearing in the written, practical and oral tests for the post of junior assistant under District Industries and Commerce Center, Kachar, against advertisements dated 17/1/2016 and 9/2/2016 made by the Commissioner so-and-so. That the following have been selected by the concerned select committee for recruitment of junior assistants. And they just give the numbers. Lordship, then the next document is what is annexed in the writ petition, that is page 38, which is what they have challenged in my writ petition. This is the page 38, annexure E. Lordship, we have to go back to the writ petition. Page 38, annexure E.
38.
Lordship has it. It's
Merit.
Yeah. So this is what they come up with. Merit cum seniority list of new appointees as junior assistant of DICC Qatar. with effect from 1/3/16. And we were appointed on 1/3/16.
So there was effectively.
This is the merit list that they prepare.
So only one merit list.
Yes, Your Lordship. We're not privy to any other. And in this merit list, Lordship may see serial number 1 is respondent number 3, serial number 2 is respondent number 4, serial number 3 is petitioner number 2, and serial number 4 is petitioner number 1. And our marks are higher, which is why, according to the rule,
You are number 4.
Lordship, we are 1 and 2.
Huh?
Serial
One-
number 1 and 2 is
Means
us.
respondent number 4, 4 and
Yes,
5.
3 and 4.
3 and 4.
Sorry.
4 and 5.
4 and 5,
Four and
Lordship.
five.
Sorry. 4 and 5. Because we got more marks, so they've gone by 5. So this is this thing. Then page 8, Lordship. I'm sorry, I have to go back to the additional affidavit.
No, why do you have to be sorry?
Page
Yes.
88 is when they call for objections. And page 100 is the final gradation list. Lordship may straight away go to page 100 because that is where the references to the rule is well, on the basis of which this merit list and final gradation has been prepared.
Page 100.
100. Annexure H. Lordship, may I read the first paragraph? It's 14th March 2022. After inviting objections and subsequent disposing of appeals submitted and decision taken in the meeting held on so-and-so in the office of the undersigned, and the final gradation list of the following junior assistants of DICC Kachar is hereby published. This has reference to the earlier provisional gradation list published so-and-so on 25/8/21. And Lordship sees the first two are respondents, 4 and 5, and serial number 3 and 4 is petitioners. And Lordship may see the last 3 lines after the column ends, the table ends. Lordship has due to joining on the same date, the inter se seniority of the incumbents at serial number 1 and 2, 4 have been determined according to their position in the merit list. Reference, the Assam Ministerial District Establishment Service Rules 1967.
All right. We'll
So-
continue.
Yes, sir. Lordship, I had shown you the page 100, which is the final thing, which makes the final gradation list relating to the rule.
Good.
Lordship, my basic submission is that nothing will turn on the fact that there were 2 different recruitment processes. Because we were both appointed on the same day. Our appointment on the same day is not challenged. That stays. The fact that we were appointed on the same date also remains. Because we were appointed on the same date, the rule kicks in. Now, to test it, supposing the clubbing is wrong, it should not have happened. Then how do we determine seniority? Because our appointment is on the same date, that cannot be changed. That stays. So we don't go by the rule, we say the rule should not be followed. Then you have to have a foundation of how to test seniority. According to them, in that situation, you go back to the date of recruitment process. Because their recruitment process in that the advertisement was earlier than us. Now, Lordship, that is in the teeth of N. Parmar. May I just, Lordship, take you to N. Parmar? Which is why I say that eventually nothing turns on clubbing of the recruitment process because our date of appointment remained the same. And if our date of appointment remained the same, then what vacancy and the process of recruitment when it happened is irrelevant, according to the 3-judge bench.
Megha
Yeah, sorry, Bekha Chandra. Yes, Your Lordship, sorry. Which overrules Parmar. Lordship, may I just quickly take you through two paragraphs of facts?
Yes.
Paragraph 4 and paragraph 5. Lordship, Bekha Chandra is a 3-judge bench, which is why it could overrule Parmar. Paragraph 4. Before the writ petition, the promotees contended that they entered the MPS Grade 2 cadre on 1/3/2007, whereas respondent number 3 to 33 were appointed subsequently, August to November 2007 respectively, and therefore they should be regarded as senior to the direct recruits. The direct recruits, on the other hand, claim seniority over the promotees by contending that seniority has to be decided in accordance to the year of vacancy and not by the fortuitous date on which the appointment could be finalized for the direct results. Then, Your Lordship, paragraph 16 is when they notice Parmar. Lordship has paragraph 16 at page 696.
Yes.
The learned senior counsel citing N. Parmar cites N. Parmar to argue that when an action was initiated for filling up of 2005 vacancies, the administrative delay in finalizing the recruitment leading to delayed appointment should not deprive the individual of his seniority. By referring to the rotation of quota principle, the council argues that initiation of action for recruitment in the year of vacancy would be sufficient to assign seniority from that date. And they rely on Parmar. Lordship, now paragraph 28. And the Supreme Court notices all the law even before this case. Paragraph 28, Your Lordship. Before proceeding to deal with the contention of the appellant's counsel vis-a-vis judgment of N. Parmar, it is necessary to observe that the law is fairly well settled in a series of cases that a person is disentitled to claim seniority from a date when he was not born in service. For example, they cite Jagdish Chandra Patnaik. The court consider the question whether the year in which the vacancy accrues can have any bearing for the purpose of determining the seniority irrespective of the fact when the person is actually recruited. The court observed that there could be a time lag between the year when the vacancy accrues and the year when the final recruitment is made. Referring to the word recruit occurring in Orissa Service Engineers rules, the Supreme Court held in Jagdish Patnaik that a person cannot be said to have been recruited to the service only on the basis of initiation of process of recruitment, but he is born in the post only when the formal appointment order is issued. Then they discuss Nani Shah, which is similar. Paragraph 30 is again Parmar. And Lordship, finally, paragraph 39 is when they overrule for Parmar. Lordship, may I read paragraph 38 and 39? 702. Lordship has?
Yes.
38. At this stage, we must also emphasize the court in Parmar need not have observed that the selected candidates cannot be blamed for the administrative delay and the gap between initiation of process and appointment. Such observation is fallacious in as much as none can be identified as being a selected candidate on the date when the process of recruitment has commenced. On that date, a body of persons aspiring to be appointed to the vacancy intended for direct recruits was not in existence. The person who might respond to an advertisement cannot have any service-related rights, not to talk of rights to have a seniority counted from the date of the advertisement. In other words, only on completion of the process, the applicant morphs into a selected candidate, and therefore unnecessary observation was made in Parmar to the effect that the selected candidates cannot be blamed for the administrative delay. Then, Your Lordship, paragraph 39. The judgment of Parmar relating to central government employees cannot, in our opinion, automatically apply to Manipur state police officers governed by MPS rules. We feel that N. Parmar had incorrectly distinguished the long-standing seniority determination principles propounded in so-and-so, so-and-so, so-and-so. These three judgments and several others like with the like enunciation on the law for determination of seniority makes it abundantly clear that under service jurisprudence, seniority cannot be claimed from a date when the incumbent is yet to be born in the service. In our considered opinion, the law on the issue is correctly declared in Jagdish Chandra Patnaik, and consequently we disapprove the norms of assessment of inter se seniority suggested by N. Parmar. Accordingly, N. Parmar is overruled. And Lordship may take the writ petition, paragraph 5. Lordship, I may read it. Paragraph 5. This is their pleading.
Yes.
The petitioners beg to state that they are senior to the private respondent 4 and 5, considering the fact that they were selected from a batch in a selection process which was held prior to the selection process of the private respondent. So their case clearly is Parmar. This is their claim for seniority. Lordship, N. Parmar case has been referred to a larger bench. But the law is that until it's overruled, it is the law. And the division bench of this.
You mean to say both these matters? N. Parmar and
Sorry.
Megha Chandra.
Megha, same
Megha
case.
Chandra.
Megha Chandra. Megha Chandra has been referred to a larger bench, but the law still remains this. That is the law of precedent, that until it is overruled, even if it's referred, the law will remain the same, and it's for your reference, Lordship, and completion. That is what even this Honorable Court has applied and relied on. That just because it is, this is only for the proposition that just because it's referred doesn't mean it's not a precedent. Lordship, last two paragraphs. Paragraph 20 and 21 on the last page. Only for this proposition that Megha Chandra still remains a precedent to be relied on.
Yes.
Paragraph 20, as we've already noted, the judgment rendered by Honorable Supreme Court in N. Parmar has already been overruled in Megha Chandra Singh, and accordingly the order of the tribunal based on the...
This is by following Megha Chandra.
Correct. And it notices paragraph 21. It is true that the decision of the Honorable Court is now being referred to a larger bench in Hariharan, but till the judgment rendered in Megha Chandra has neither been overruled nor modified and still holds the seal and therefore cannot be overruled. And Lordship, if Lordship wants the Supreme Court judgment which deals with precedent, which basically says the High Court must rely on it until it's overruled. Just because it's referred, may I?
Yes, sure.
So, Lordship, short of the fact that our appointment is set aside, the fact of the matter is that we were appointed on the same date. And without there being a challenge to our appointment, at the end of it, the existing foundation to determine seniority, even if we don't go by the rules are there, which says merit. Even if you don't go by the rules, it goes back to the date of appointment and then again merit comes in. So therefore, even the clubbing or the different recruitment process,
yes,
in the analysis of the case will not matter.
Which paragraph in the last judgment?
Paragraph 35. 2024 Lordship has?
Is the Jammu Kashmir matter?
Yes, Jammu Kashmir. Yes, paragraph 35. Lordship wants me to read it?
page 93 of the affidavit in opposition filed by the respondent 4 and 5, where they have annexed the rule. Note part, at the beginning of each calendar year, the deputy commissioner shall call for applications to fill up temporary vacancies of any kind which are likely to occur in course of the year in their respective establishment. On receipt of application by a specific date, a test shall be held and a list of all suitable candidates for appointments to the post of guard division prepared in order of merit by the applicant. My lord, this is pertaining to, my lord, when there is a test, a particular, my lord, advertisement. In the instance case, my lord, two different separate selection process, my lord, which was initiated by two advertisements. Now, my lord, clubbing of two select list, my lord, mark sheet, different mark sheets were, my lord, published, my lord, in 42 of my petition, my lord. Next, the first page and second page, page 42 and 43, my lord. Now, my lord, first advertisement was issued for filling up of two posts, one for general and one for OBC. And second one is, my lord, for one STH and, my lord, one for general category candidate. Now, my lord, record would repeal my page 42, lordship. The petitioner number 2, my lord, belongs to OBC category. He got 69.65, whereas petitioner number petitioner 1 and petitioner number 2 is the general category candidate, my lord, who got 81.65. Now, mark sheets of second phase of selection process, my lord. This, my lord, 83.95, my lord. This is rapid respondent number 5. She belongs to STH, my lord, which shows that, my lord, she got more marks than petition number 2, my lord. Now, if she being a, my lord, scheduled tribe candidate, my lord, if she got more marks than, my lord, general category candidate, my lord, she would have got selected, my lord, being a general category candidate, my lord. In that review, my lord, they have prepared two different lists, my lord. Page 42 pertaining to first page and page 43 pertaining to page 2, my lord. Page 42, my lord, of my writ petition, lord. Signatories are the, my lord, selection committee, my lord. Page 42. 42, my lord. Annexure G, my lord. These are the candidates and their marks, my lord. 48 is the petition number 2, my lord, and 93 at serial number 4 is the petition number 1, my lord. 81.65 and 69.65 got by the petition number.
These are mark sheets.
Mark sheets. And subsequent mark sheet, my lord, page 43, my lord, which shows that, my lord, 3 and 4, they are the private respondents. 83.95 got by private respondent 5 and 4, 87.77. Now, my lord, clubbing, my lord, private respondent number participated in the selection process being a, my lord, STH, my lord. STH, when she got 83.95, my lord, it is above petition number 2, my lord, 81.65, my lord. So she could have been appointed as, my lord, general category candidate, my lord. So, my lord, these, my lord, final.
How does it? What relevance has it got?
No, my lord, this will disturb, my lord, entire the selection process, my lord. And apart from this, my lord,
This is the mark sheet. Is there any select list published?
Select list, my lord.
Only one.
Select list, my lord. This is notification issued, my lord, page 44, my lord. There also, my lord, they have specifically stated, my lord, the dates of interview, all these things, my lord. Now, my lord, this seniority list was published in the year 2020, my lord. And as per this rule, my lord, which I have shown your lordship, that it's required to be published each and every year, my lord. And that pertaining to a single selection process.
Is there anything you'd like to submit with regard to the judgment?
No, my lord, judgment, my lord, those are regarding seniority, my lord. I am here, my lord, for how the clubbing was done, my lord, whether that is permissible under law. Considering these two aspects, my lord, the mark sheets as well as, my lord, the law itself, my lord.
No, show us the law.
No, my lord, this note itself shows that, my lord.
It's not sufficient.
It shows that, my lord, for a single selection process, my lord. This is not, where
is that note again?
My lord, page 93, my lord.
At the very beginning, by direct recruitment on the basis of a competitive examination to be conducted by Deputy Commissioner at the beginning of each every year, unless otherwise directed by government in that.
So there is one list
Now,
for appointment.
note, my lord, at the beginning of each calendar year, the Deputy Commissioner shall call for applications to fill up temporary vacancies of any kind which are likely to be occurred in course of the year, respective establishments. On receipt of applications by a specific date, a test shall be held, and a list of all candidates, suitable candidates, for appointment to the post of law division shall be prepared in order of merit by Deputy Commissioner, my lord. This is pertaining to a particular test, my lord. And here is a case, my lord, two different selection process, my lord. The question pattern, everything are different, my lord. Recruitment are independent candidates, competent, different examination, my lord.
What's the law if you have it?
Now, my lord, regarding this, my lord, two different selection process, my lord. So, my lord, I have shown your lordship the advertisement, my lord. After the advertisement itself, my lord, last part, my lord, those who are qualified in the practical test will be called for the oral interview. The final merit list will be prepared on the basis of mark obtained in the written test and practical test and oral mark. So, my lord, there is no whisper that, my lord, in the first advertisement as well as second advertisement itself, they could have mentioned that on the basis of performance of earlier advertisement and as well as this one, a select list will be prepared, my lord. After completion of entire selection process, my lord, they cannot change the rule of the game, my lord.
All right. Heard reserved.
Obliged.
Records furnished to the court are kept on record. Till delivery, you get it.
Obliged.
I'm being attended 61.
The matter may kindly be adjourned for today, Lord. My seniority makes court number 23.
On the request made by the council for the petition, the matter stands referred to be listed after 2 weeks.
Lordship, on Monday, Lordship, no.
After 2 weeks.
Lordship.
Right. So this matter, the hearing step was completed. Lordship directed us to file a written submission. My learned friend also completed the argument. The issue was that about the notice on the 74, whether the two conditions of the 74 were fulfilled or not. Now, Lordship has also on this issue delivered the judgment in the context of the service tax by examining 73, one of the act. An entire law, 73 of the Finance Act is parametered to section 74. And after Lordship, after examining the entire, all the case laws under the Central Excise Act and all of the laws, came to a conclusion, that unless and until there is suppression with the intention to evade the payment of taxes, their notice cannot be issued. And also came to conclusion that non-filing of the return or non-payment of tax is not a ground to hold that there was suppression with the intention to evade the payment of taxes. And I have also made written submission along with the judgment.
I have to refresh the memory. Can we have it on second? Sorry, on 9th. Subject to convening.
Mine, I have no problem, but you also got the problem. You also mentioned it's for further hearing. Further hearing was listed, allowing the matter to be listed unless you also.
We keep it part heard. We have heard it. It's not. Matter will be listed on 9th for further hearing. Matter will be treated to be part heard.
In the interim order.
Interim orders, then you will continue.
Well,
we'll have to hear and.
My learned friend also wanted to file a new submission. In the meantime, he can also.
On 9th after hearing, he wants to file. Dr. Saraf, Senior Counsel, assisted by Mr. K. Bora and Mr. A. Course, Mr. CPL, Senior Counsel. GST Department. assisted by Mr. Jain. Respondent number 225. Mr. Dhor. Mr. R. Dhor for PWD. Released on 9th. For further hearing.
We have the instructions in this manner.
Affidavit.
Lord, on 23/6, they took time. That
It has come, my lord. Such a
Why after such a long time? 1 year almost. Some affidavit has been filed, no?
affidavit filed earlier, but at the same time, they said, my application has been rejected. So if that is so, that has to be brought on record. And in fact,
Why is it necessary to be brought on record?
Yeah,
We'll take judicial notice and
no, the only thing like if that order is passed, that order has to be challenged.
we'll challenge it.
But that order has not been furnished to us.
Give it to us.
So
It's not here.
No, I have the order, but how do I? That is what I want to.
We'll take judicial notice, give it to us. We'll put it in the record.
Fine.
Yesterday.
Let a copy be furnished to me. I have one
Then
copy.
you are entitled to take
Yes,
records.
Fine.
On that account, why the matter should
Well,
be
in fact, on
deferred?
the last occasion, there was no, the letter was not there. That is why they sought time to file the affidavit.
1 year back, almost. Yes. Why are you sitting on this letter, not serving, giving him a copy?
Fine. I will fix next week this matter. I will bring this on record, man.
Mr. R. Dhor, counsel for the PWD, submits that the matter be listed on 10th. By which date? By 5th. Bring it on 5th. By which date you would like to bring on record the order passed by the department rejecting the claim of a writ petition?
My lord, can it be on the 7th, my lord? 5th is
Friday.
okay.
Not good for you.
No, my lord. Every day is good for me, my lord. I ordered.
MS so and so appears for B for BTC.
Both of us have taken instruction, but matter may perhaps be referred to mediation. Is the after
Arbitration matter.
lordship, because there is both of them are in the same family members. Petitioner and respondent number 3.
It is submitted by the counsel for the petitioner that after filing of this, submitted at the bar that after filing of the present application under 11.6, the parties have expressed a desire to resolve this matter through mediation. Accordingly, the matter is referred to the Gauhati High Court Mediation Center. The parties are directed to appear before the mediation center on 5th. 5th of June.
So in fact, the parties are desirable to settle all the disputes first.
Settle it, get a settlement deed executed.
And also, if required, can the parties appear via VC?
That is for the mediation to decide. Ordinarily, there's no reason why it cannot be permitted, subject to facility being available.
That indication may be given.
They are resident of which place?
Both the parties.
Some medical
issues.
Then you appear before the mediation center in Tezpur. Districts.
They are inclined to have the mediation in the High Court.
Then we don't know whether facilities are there or not. Mediation center will, registry will permit the parties to appear to hybrid mode if such facilities are available. That's before the Gauhati High Court Mediation Center.
Others are identical, all pertaining to my lord entitlement under the old pension scheme. Lordship knows that there is a cutoff date of 22 December 2003. If the process had started, even if the appointments had come thereafter, the process of recruitment had started before this particular date, everybody is entitled. Now, my lord, in a litigation in Delhi High Court, around 4,000 names of Assam
Because of the departmental delay, they were appointed after the cutoff date. Is that your case?
My case is, my lord, that the process started and the recruitment really ultimately ended, my lord.
Process started during the period of old pension scheme.
Old pension scheme.
Because of the process, delay in the process,
My lord.
final appointment orders were issued after February. That is your case.
My lord.
There is a judgment of this court.
There is already a judgment of this court. And in fact, lordship, what happened is that Delhi High Court for Assam Rifles, when all these paramilitary forces have together gone there, my lord, a list of around 4,000 people were submitted that these people would be entitled. That list included us also. And since no steps were taken thereafter, my lord, we approached this court and this court was again pleased to pass an order in case 221. Case 221. Direction was issued to the respondents to verify the facts.
All right, then what happened?
This was passed on 8/11/2023. Immediately thereafter, my lord, I don't know, within 10 days what they have done. 21st November 2023, a list of around 1,300 people are brought out saying that these persons are eligible. We were left out. So we are again, lordship, saying that our cases have really been clarified.
No. On this aspect itself, there is a matter. I think there's an order, there's a division bench judgment.
Yes, the lordship was a party then. That case.
I was not a party, I was
sorry.
a member of the bench. Yes.
302, my lord. 302.
302.
Connector 11. Oh, no. No, I think. Division bench judgment is similar. In fact, sorry, my lord, it's 284. 284. In fact, lordship has authored that. This is otherwise settled, my lord. Why we are being held back is, my lord, they say that there is no data available to
Is it in the same line as this judgment? No.
This covers us in the fact that we are eligible, we will be permitted to give the option.
Now you are challenging this subsequent order.
Subsequent order which says that we are not included in the person's eligible for
pleadings are exchanged.
Pleadings are exchanged. The ground, my lord, that they have stated is that firstly they said that the advertisements could not be found, my lord, pertaining to our, my lord, claim. And that I doubt, my lord, because within 10 days from the order of this court, I don't know how they have completed this massive exercise of verification and filtered out only certain persons. Secondly, as far as advertisement is concerned, the respondents cannot hide behind the fact that it is their records, employment records. They don't find it, my lord, how I can be put disadvantage because of this. Thirdly, my lord, if your lordship sees the Annexure 1 page 80, my lord, the recruitment process, my lord, started, as we can see, my lord, from 24th September 2003 when this advertisement was, my lord, approved. But instead of taking this 24th September 2003 as the date, they have taken the date of 31st December 2003
which is the letter thereafter written to the Chief Secretary saying that to make arrangements locally for the conduct of the physical rally. So this particular communication is not the date on which my recruitment started. So this aspect again, all other relevant papers as to what was the background, my lord, of this recruitment, we have filed an additional affidavit also. Not the only thing we cannot, of course, go into all these details. Only where I can think now is that they have to re-verify now basis on the basis of the documents that I have given and try to find out those advertisements relevant. And the entire exercise should be. So what is the ground in the affidavit they have taken?
May please, Your Lordship. In item number 55, madam, here I did not file that affidavit in opposition, madam. That is, I have received the affidavit in opposition, madam. Some annexer are eligible. We are going to file in, madam.
All right. In the other matter, there is an affidavit.
Yes, other matter affidavit.
What is the ground for rejection? The ground, my lord, they say that as I point out from my Annexer 1, Annexer 1 is dated 31st December 2003. They said that this letter is after 22/12/2003. This is the cutoff date. Therefore, you are not coming. Where is the cutoff date reflected? Cutoff date, my lord, it is in the circular itself, my lord. Is it available here? My lord. In fact, it is recorded in your lordship's judgment also. Which letter you are referring to now? Now, my lord, page 79, Annexer 1. 79. This is the letter, my lord, for making arrangements of the rally. This is given to the Chief Secretary. But then the recruitment rally process, my lord, if your lordship look at page 80, comments from 24 September 2003. Process definitely, my lord. We also don't have the detailed records, my lord, because we never knew that this situation was going to come. Nobody is going to preserve advertisement of 2003, particularly this low rank, my lord. Now, in view of that, they have taken a stand now that we we fall beyond this particular cutoff. But then in the additional affidavit, my lord, we have pointed out that this particular letter of 24 September 2003 also we have, my lord, enclosed. The SOP for this particular recruitment was issued on 23rd April, then 25/7/2003 vacancies were approved. Rallies were approved on 24th September 2003. Then other WT messages and directions were given. Ultimately, by this 31st December letter, my lord, the rally was actually physically directed to the end. But then the recruitment process, my lord, started before 22/12/2003. So that aspect, my lord, they have not dealt with. My additional affidavit also has not been replied to, my lord. So all that I can pray for is that they have to, my lord, re-verify our cases as of now. And they cannot just take it up. No, but how do you say it started prior? Because your page 79, my lord, is a communication issued on 31st of December. And this is for making arrangements for the conduct of the physical. This physical rally was started from 1st of March. Yes. 2004. February, March. Yes. February. Not February, March. March, my lord. This case, March. In some cases, there are February also. Where is that judgment again of the division bench? 284, man. They are members of what? Assam Rifles. Assam Rifles. The present petitioners. My lord. I think at page 290, para 9.
Here, of course, there was no dispute that recruitment process started before 2000. But in my case, my lord, the records are still not clear. They say that, my lord, it is.
No, if you're relying on 79,
My lord.
it is clear that it did not start in 2000.
No, lordship would look at page 80 also. Page 80 is the part of the same correspondence. My lord.
Started in 2000, February, March, April 2004.
This is the notification by which the dates for rally was fixed and arrangements were
What
asked
is
to
the
be
cutoff
fixed.
date for the new pension?
22,
2005.
22/12/2003. But then page 80 at the top, my lord would see an open recruitment rally in the following any reason have been approved to be held under arrangement of respective month, filed later date 24 September 2003.
But the process did not begin.
This was approved.
Process did not begin. Approval is one thing. In the division bench matter,
there was no dispute.
There is no dispute that the process started but completed after 2005. Then let them file their, complete their pleadings. We'll take up both the matters.
Their affidavit again says, why in saying that we best can ask for a re-verification? They say that, my lord, they have taken this particular date, taking you from my requisition, saying that this is the date. But then, from when did the advertisement actually start? It's a record to be like dug out by them.
Records are not available.
They say the advertisement not found.
Huh? Mr. Goswami?
No, in fact, till that record is not found, we filed our affidavit in this particular matter, as pointed out by my friend. Here, the recruitment process was initiated after that cutoff date. That is our stand, and we enclose annexer R7.
These advertisements are made in what? In
that is why our stand is that they are not covered under the whole pension scheme.
Normally, they put up in the employment exchange, my lord. This is how people come to know, and also in local newspaper. But then, in our case, my lord, what you could see on 8th November, lordship directs them to verify. Within 10 days, they complete this Herculean task. And in our cases, they simply say that advertisement not found, advertisement not found. It is their duty to, my lord,
what steps did you take to verify, Mr. Goswami? What is the process of verification?
Find out actually whether they are eligible whether they have applied within that process cutoff date is there or not. In fact, our stand in the affidavit is that yes, against each and every person, documents are there. They found that they are not within the cutoff date.
I'm asking you, what is the process? How did you conduct the process of verification? It has to be done vis-a-vis each candidate. So what was the process undertaken? What documents did you examine?
Based on the relevant service particular of the person, definitely. How specific or instructions you have to obtain? Definitely, on the service particular verification has been done.
How many candidates are here now? Repetition.
Stand matter, my lord,
around, my lord,
2.
different numbers, different cases.
372.
It will be around 300.
No,
more than 300.
Other matters are
there is no
different.
dispute with regard to your date of appointment, etc.
Yes, my lord.
There is no dispute.
No dispute.
Now, you are only trying to get the benefit by saying that some decision was taken in September. Now, decision taken in September, does it confer you right?
Not just the decision. Not just the decision. There's then again, Lord, you would see at page 352.
unless they said that advertisement not found. How can I produce the advertisement, my lord? Forget advertisement not found. The advertisements, where the candidate had responded to the advertisement, whatever they. You will have your own service books to indicate the dates on which you were appointed. Now, is there anything on record or material available say that the advertisements were issued in September or November, you applied?
Advertisement might not, they have to find out. I cannot find out, my lord. That was precisely the reason that lordship had asked on the previous
These
occasion. Asked them to
advertisements
verify.
were issued through employment exchange or newspaper?
Employment exchange,
Okay.
various sources, various sources. Employment exchange and
Who issued the advertisement, Mr. Goswami?
the authority, my lord.
No, authority.
Equipment, they,
Who is the authority?
not only the Assam rifle, it's a central director general. Because I have given, my lord, particularly their response to my additional affidavit is also required. Because I have given in material like in page 393.
Is there any statement in the affidavit that the advertisements were not issued in September, October, or no? Is there anything in record?
The affidavit, we have specifically stated, page 327, para 9. Sixth line. The scrutinized the record of the board of officers convened on so and so date. It was found that only 16 recruitment releases were carried out, whose the date of advertisement notifications were issued prior to 22 December 2003. As already commented on the paragraph 7, the advertisement notification of the present petitioner were issued after 22/12/2003, and the advertisement notification not visible to grant of all. This is totally correct and justified. Yeah. Next page, the recruitment, the employment date, advertisement is given. 5 releases are mentioned here. All of those releases in 2004.
In these 16 rallies, page number 327, you say 16 rallies were carried out. In these rallies, who were the petitioners who were selected?
The petitioners are not from these release. These persons are given the benefit, but the present petitioners are not from this recruitment release.
They are from which recruitment release?
Different release, but not these. These were selected. They got the pension as per the old pensions.
Okay.
But they are a subsequent release. Recruitment release.
No, so which are these rallies? That will clinch the matter if you.
Lordship, all are different release. Different recruitment release.
No, different, may be different, but after the cutoff date.
Yes.
That statement has to be there.
In my opinion,
In this particular paragraph, next page, the recruitment releases are mentioned. 5 recruitment releases are there. A, B, C, D, and E. All these releases are after the cutoff date.
And it is in these rallies that the petitioners are shortlisted.
And why this is self-contradictory, my lord? That is why I was pointing.
What is self-contradictory?
They said that this advertisement we know is after 22/12/2003.
Page number?
But then in page 352, my lord, they say that advertisement not found. They have not found the advertisement. How did they know that the advertisement is after 22/12/2003?
Where is it stated? 352.
352.
352.
352. There is a chart, my lord. Second line.
What is Samsai rally?
Samsai is the place, my lord.
Advertisement, every form of advertisement may not be available, but the dates could be available.
They have not stated so. If they have not found the advertisement, how can they say that the advertisement is after my lord? Cut off date. What they have stated to be the advertisement.
What hinges on the advertisement?
Because the advertisement is the
Advertisement
point from which the recruitment starts.
is the beginning of the selection process. Your process must conclude before the cutoff date.
No. Process should start before the cutoff date. And even if appointments are made thereafter, people are covered under the old pension scheme. They are eligible to give the option.
I don't think that is the correct position is
No,
that the
very-
selection process must be completed. But appointment
No,
orders, even if not
very
issued,
circular is might not very clear. 2003, circular on NPS, my lord. And in fact, your lordships has also held in the division bench judgment that the process started. In that case, there was no issue because there was no dispute that the process
no,
started.
in that
before.
judgment, the process started and the selection process also concluded in a sense of the tests or whatever written examinations were required to be done. Only the select list was published and appointments were made after the cutoff. Where is that circular?
Lordship would look at the affidavit at page 346. 3rd March 2003. Page 347, my lord, is para 4. It has now been decided in all cases where central government civil employees have been appointed.
Para 4.
Appointed against a post or vacancy which was advertised, notified for recruitment appointment prior to the date of notification for NPS and is covered under NPS on joining service after 1 on 2004 may be given a one-time option to cover the CCS pension. This option may be exercised by the concerned government service. From the date of vacancy advertisement, my lord, the process starts. But an appointment also comes after this particular cutoff. They are given a one-time opportunity of giving the option. This was the verification, my lord, at the rate. Within 10 days, they have conducted the verification and it appears, my lord, they have taken the date of our advertisement. That is the date. They have indicated that actually the date on which the respective chief secretaries were asked to make physical arrangements for the event. The advertisement they did not look for or they could not find. So therefore, my lord, I am saying that these are cases which have to be re-verified. Even if we call for the records, my lord, it's difficult to undertake that exercise.
You're disbelieving their statement. Is that what you're trying to say?
My lord. My lord.
You're disbelieving.
Not disbelieving. My lord, they are themselves contradicting themselves. They have taken a particular.
No, see, the notification says date of which is advertised or notified for recruitment. So it can be either advertisement or notification. So advertisement may not have been applicable. Are they? What about notifications? Are they available? Mr. Goswami?
Follow.
Are the notifications for recruitment available? Come to page number 352. 352.
I am coming.
352, you have given various dates.
Follow.
And on the right hand corner, you have said advertisement not found.
Follow.
Now, is it a case of advertisement not found means that advertisement was not issued? Instead, some notification was issued?
What happened, Manoj, these are the old advertisement of 2004, Manoj. That is why it was not found most probably after verification. That is why whatever the actual fact that is placed for the Honorable Court, Manoj. In fact, Manoj, the process as indicated in the paragraph 9, Manoj, that particular the 5 numbers of
No, then
equipment
if
relay
you,
under which they have.
if you say that these dates are not available, then the question would be that how do you say that these people are excluded from the purview of the notification?
What happened? Advertisement means Manoj, a particular cutting or something like that. That was not available, but the recruitment drive was initiated in a particular Manoj date. That is why it is mentioned at the paragraph number 9.
Recruitment drive will be initiated
That really
from a date which has to be notified earlier. How else will the participants know? If you are saying that the recruitment date in from page number 352, you are saying that date of common competition, this is 2004. So this date will have to be notified earlier. And if this notification is prior to the cutoff date, then their benefit will have to be given as per your own circular, for which it is necessary to find out.
I would just like to take your lordship to one last page, madam. My additional affidavit, if your lordship comes to page 395.
One. Yes.
Page 395. Why I'm saying that this started from 24 September 2003. This is the recruitment program, my lord, under which we were appointed. Now, thereafter, lordship would see at the bottom, note, respective branch headquarters are responsible for publicity of the rally as per para so and so letter of 23rd April 2003. So, immediately after 24th September 2003, a public notice was put up, my lord. Response to that notice only came. The letter they are quoting is a letter directed to the chief secretary, not issued to the candidates. Then you make arrangements that on these dates, rallies would be held. Make the physical arrangements, including other arrangements from the civil administration. So definitely there is a notification or a public notice put up somewhere after 24th September 2003. Now, since they have not undertaken that exercise to find out as to which is the date, therefore, my lord calls for re-verification.
So in this WPC 6153, details are not available.
In other cases also, my lord, the same thing has happened. Everywhere they have stated that the notice that is issued to the respective chief secretary to conduct or to make arrangements for the rally is the date of advertisement. But then the physical advertisement or actual notice given to the candidates as you applied, that has not been looked into and that has not been. Which, according to us, is the relevant date, my lord, from which the recruitment process started.
Where have you stated which item number?
Page number 359 of this affidavit. This particular matter, 359. It's continuing the annexes. Again, verification has been made. Found that the recruitment really was indicated in the middle. Date of advertisement is given. All those advertisement, date is given in the whole.
How do you correlate 359 and 352? Is it one and the same or different?
The forwarding letter is 358, 6 January 2025. On the basis of the particular of the petition.
So we are asking you.
The record branch,
352 contains certain information against certain persons. And 359, according to you, reflects the date of advertisement.
Advertisement of the particular, the writ petitioner of this case, no, is indicated in the top of the issue.
These are the writ petitions.
No,
All the writ petitions.
no, their names are there. No. Verified, it found that
So advertisement is dated 1st of May.
Mal.
So if this is the report, then Mr. Pathak, no further inquiry is necessary. And in Mr. Pegu, what is your affidavit? 192. One? Uh, but where does it indicate? One? 196. This is the selection, this is the what? The advertisement. Okay. Yes, Mr. Pathak.
Come back to the first item itself, my lord. Annexer 1, my lord, that I had pointed out, they initially say that these are the dates on which rallies are to be conducted. Beginning from February to May, my lord. And thereafter, somewhere they indicate that it is 1/5. If advertisement was earlier not found, my lord, if the advertisement is found, let them produce the advertisement, my lord.
No, this is. You bring on record to say that there was no advertisement given.
Yes, my lord.
Why should we get into this asking them? They've filed an affidavit on record, stating that this was the date of advertisement.
My lord. We have, in response to that, filed an additional affidavit by saying that you had been asked to notify these vacancies and advertisements in September 2003, and thereafter the process started. Now you are taking the date of conducting the actual rallies physically to be the date on which advertisement was issued. But then we were informed much prior to that.
So why don't you check up yourself 1st of May 2004? What materials are available for you? Where is that advertisement? Give us a sample copy. 1st of May 2004. From the record somewhere. Is it available, Mr. Goswami?
not trace out, my lord, just now.
All right, give us a copy. Take it up next week. Bring copies.
For us, my lord, it is difficult to dig into those. The situation in these cases at arisen that nobody was contemplating that they will get a chance to get into the old pension scheme. But because of certain judgments and DOP notifications, this option had opened up.
Heard Mr. B. Pathak, learned counsel for the petitioner, Mr. K. Goswami, hearing for the respondents in 6153. In the same proceedings, pleadings are exchanged, and in the affidavit filed by the respondent, there is reference to a communication at communication dated 6th of January 2025, wherein the particulars of the writ petitioners in WPC 6153 was examined and reflected. In the said chart, the date of advertisement for the rally undertaken towards the recruitment of the writ petitioners was shown to be advertised on 1st of May 2004. However, copies of the advertisements are not enclosed to the pleadings. The counsel for the petitioner, referring to an earlier communication, dated earlier communication, which is reflected as annexures R7, page 352 of the affidavit, submits that by this communication, although the various particulars are reflected insofar as the writ petitioners and other similarly situated candidates are concerned, however, it was clearly mentioned therein that the advertisement was not found out. Therefore, submits that there is contradiction between this document produced at annexed at annexure R7 and the document at annexure R7, page 352, and the document enclosed to pay at page 359. He submits that the petitioners do not have copies of the advertisement, and the respondent directed to produce copies of the advertisement if they are available. Is the claim of the petitioner that the writ petitioners firmly believe that all the advertisements were prior to the cutoff date as reflected in the web dated 3rd of March 2023, which is cutoff date, which is 22nd December 23, as is reflected in the OM dated 3rd of March 2023. Mr. Goswami submits that he will have to get his instructions and obtain a copy of sample copy or copies of the said advertisement and produce it before the court. He prays for up to next time. MS A. Gayan, representing the respondents in WPC number so and so, submits that the affidavit is in the process of filing. She require next time to complete her process and file the necessary affidavit. MS B. Sharma appears as CDC in WPC number so and so. Mr. Pegu appears for CDC in WPC number so and so, and Mr. H. Gupta SCDC in so and so.
Item 53 also may not affidavit now.
And I am in item number 50 and 51 as well.
50 and 51, the number. The done CDC for the just appearing for the respective respondents in the petition that permitted complete their pleading by the next internal list accordingly. Yes.
Finally, peruse the order dated 23 my lord. Part of the non-payment of compensation of family pension. The husband of the petitioner died 27/1/2025.
22/3. 22/3.
My lord, 27/1/2025.
No. Which order you're referring to?
23 my lord. 23 my lord. That my lord, under process. But as per my instruction, my lord, no step has been taken by the respondent number 5, my lord. District Commissioner, my lord. Did not call her, my lord.
This is what we actually received, and we have written to them as a reminder also. This recently, 8th of May, taking the answer with regards to this letter, but nothing has come forth.
Mr. K.R. Patgiri, counsel for the petitioner, submits that the respondents were required to produce the status of claim of the petitioner for family pension, as it was earlier submitted that this claim was under process. Whereas Mr. D. Bora, State Council, submits that in spite of instructions being sought for, up-to-date instruction is not available. Who is supposed to give you?
District Commissioner Lakhimpur.
Accordingly, let this matter be listed again on 15th of 15th of June. By which date? The additional, which district commissioner?
District Commissioner Lakhimpur,
District
respondent number 5.
Commissioner Lakhimpur, namely respondent number 5.
Hello.
Will furnish all necessary instructions as sought for by the Government Council regarding the status of the process of the claim of family, compassionate family pension so far as the writ petitioner is concerned. Let this matter be listed accordingly on the next returnable date. Stop if instructions as directed are not forthcoming, then consequential orders may be passed by the court. Instead of 15, make it 12th. 12th of June.
At least provisional family pension may be.
Pendency of the writ petition is not a bar for consideration and release of family provisional family pension. Provisional compassionate family pension, the writ petition. Based on 12th of
Obligation.
My lord, you will find my lord, page 68 is the input order.
page.
Page 68.
Meetings are complete, Lordship. Kindly fix it for admission and another.
What is your claim?
My lord, the gentleman has been my lord, terminated from service without giving any notice. My lord. Page 68, lordship will find input order.
Some inquiry was held.
No inquiry.
The provisional appointment was issued, Lordship. He is in the training period, Lordship. At that time, it is come to know that he was earlier appointed as Agnibir in the subsequent department, that is
Army.
Army, yes, Lordship.
Therefore,
And
he has resigned.
not resigned, Lordship. A complaint was received from the airport Army, Lordship, and that's why notice was issued to him, Lordship. Notice was issued, and he has also replied
file reply notes. We have stated, file our affidavit and there we have stated.
Which paragraph in your affidavit?
Yes, that's it. 100. Page 99, Lordship. Here it is, he submitted his reply, Lordship. Clarification regarding registration from, resignation from the post of agreement. Clarification. He has not even completed his training period also, Lordship. During the training, he was found, complaint was received from the army, Lordship.
Where is the order of termination?
Page 68.
Now, from this order, so many things are not available. Where is it? Your affidavit has given long explanations. There must be something available in the records. This order does not reflect anything.
Yes. Yes, Lordship, I have annexed the clarification receipt from the petitioner, Lordship, and also stated in our affidavit.
That is what we are saying. In your affidavit, you have explained the order.
Yes.
So you have explained the circumstances under which the order is passed. The order itself does not reflect. Order does not say that these are the grounds on which he has been discharged or relieved or released. So there must be something available in the records which has led to passing this order which is under challenge.
Yes, sir. What may be there also.
So you have to get the reports.
Yes, Lordship.
There is the stand of the respondent is that you did not get a proper discharge.
I have resigned. That has been acknowledged by the department also.
Which department?
The ODB department. ODB.
Where is that resignation letter?
Yes. My resignation, Lordship, will find at page 33.
That is not duly, that from that it has not come to know that whether that resignation was received by the department or not. No seal is or anything is there.
Page 33, Lordship will find. Then, my Lord, page 34 is the acknowledgement. It is downloaded from the internet, my Lord. Then page 35 also. Then again,
Is there any form required to disclose that you are serving or you were serving under any other services in the application form which is filed for CRPF?
That should be
to verify also from advertisement notice also. Advertisement, not annex.
This is the application he has sent. You have sent.
Sent.
Where is it received?
Lord, page 34.
34.
And my lord, again, my lord, page 35. Article number so and so received Alwar headquarter on 9/1/2025. And he joined in my lord CRPF on 22/1/2025.
So barely sending a letter, is it enough to say that you have resigned?
But that has been my lord acknowledged by them.
Where is the acknowledgement?
Page 35.
This is the postal receipt.
Yes.
35 is the postal record.
Yes.
So
Then-
why do you say acknowledgement?
Page my lord 36 also. This is the speed post, my lord.
Postal record this.
The postal records. Where do you say acknowledge?
My lord, it says my lord, article number so and so
This is the postal receipt.
out for delivery. Pro emit Bina bit number so and so on 9/1/2025. Yes, this is not acknowledged, but it has been my lord, delivered. It says my lord, it has been delivered.
What is the procedure? Under what provision were you appointed under Agnivir?
Now, my lord, my clarification you will also kindly see at page my lord 99 in my friend's my lord affidavit, page 99. I have clarified. My lord.
In your did you enclose the application form? Is it available here?
Application for my lord, for resignation.
No. For appointment in CRPF?
Appointment for CRP, my lord.
This-
Offer of appointment, page 65, my lord. Page 65, that is the my lord, offer of appointment.
They have rejected you on the ground and you suppressed this information.
That
Did
is
you mention in your application?
Yes,
Now-
point B, Lordship. Always point B, page 65 and it's
You get the records pertaining to his selection process in the CRPF.
yes.
Application form, what he is given, what he is not given, everything has to be there.
From
Yes,
A
that-
and B.
No, but where is it reflected?
In the appointment, offer of appointment.
So where does it say that he is not disclosed?
He had that is.
These are the conditions. Your order says he has violated it. On what basis? What is the material? From where do you say that he has violated these conditions?
Yes.
I have to.
The writ petitioner is aggrieved by the order of termination issued by the CRPF authority on stop. In the affidavit filed by the CRPF, there are averments to the effect that the writ petitioner suppressed materials at the time of recruitment in the CRPF. He did not disclose that he had resigned or he had served under the army in Agni as a member of the Agnivir within quotes, and the process of discharge was not as per rule. Stop. Upon receipt of complaints from the army authorities, proceedings were initiated and the writ petitioners were dismissed by the impugned order. Stop. According to the respondents, the disclosure necessary, mandated under the letter of appointments were violated by the petitioner, and therefore the process of termination was, the order of termination was. Whereas in the affidavit filed, there are no references seen to the application form or to the information declared. Application form, the information submitted by the petitioner in respect of his earlier services under the army. So, learner CBC therefore submits that she would like to complete her instructions and submits that matter be posted after 3 weeks.
In page annexure 4 and 3, it is
4 and 3 of
our affidavit also, page 94,
94.
annexure 3. Regarding desertion from Indian Army, reference your office signal dated so and so, dated 22/5/25, since no
93.
94.
94.
Page number 94, annexure
Annexure
3. R3.
R3 is 91.
Dated 23/5/25.
Yes, 91.
Yes. Desertion from
So what steps have you taken?
after that 95 also.
What steps have you taken?
Clarification. After that, he has informed required clarification regarding clarification on recruitment in CRPF after deserter from Indian Army is referred.
No, you get your complete records.
Yes.
List. Immediately after you.
It kindly be fixed, otherwise it is very difficult to get listed.
21st July. 21st July.
Can it be earlier?
Earlier there was a vacation for holidays.
On 17 or 20
Of
July. 17 or 20.
17 or 20. All right, 17.
Plus.
Only.
Yes. Yes.
My lord, this is, my lord, pursuant to lordship's last order, my lord, petitioner is continuing in Nagaon, my lord. And similar cases were disposed of by your lordship in 2 different orders, my lord. Just I am and referred, send it to the my lord department for consideration. Two different petitions. Same facts and everything.
Yes, what do you say? Cooperation?
Lordship, I have not received the instructions yet, Your Lordship. But
There is some representation pending.
yes, Your Lordship, the representation is still
So
pending,
you
Your
dispose
Lordship.
of the representation.
Lordship.
Tax, I don't know. Continuation to the earlier order dated 6/4/2020. Hard so and so. The continuation to the order dated 6/4/2026. Petitioner has been working as assistant. You're working as senior
cooperative.
Huh?
Senior inspector of cooperative society.
senior inspector of
Cooperative society.
cooperative societies and posted at
My lord, Nagaon.
Nagaon.
Page 30.
Stop. Since the petitioner was appointed as a sector officer during the ensuing during the last assembly elections, the transfer of the petitioner by the impugned order dated 15/3/2026 did not result in the release of the petitioner from his place of posting in view of the exclusion given under the ECI guideline dated 9/2/2026. Since the petitioner had continued to be in his place of posting by the earlier order dated 6/4/2026, an interim order was issued. Action to the petitioner. Stop. Whereas today, when the matter is called up, the Learned Standing Council Cooperation Department submits that instructions have been sought for, but the same has not been received. Stop. Counsel for the ECI, Ms. Eskataki, submits that no action is called for at the level of the ECI, as the code of conduct is no longer in place. Rather, the same has lost its force pursuant to the new government being sworn in the state. So, we are considering the fact that in spite of opportunities being granted, instructions sought for have not been received. This court is of the considered opinion that the matter can be disposed of since the representation is stated to be pending before the
Secretary.
Secretary to the Government of
Secretary to the Government of Assam, Department of Cooperation. Stop. Let the Secretary to the Government of Assam, Department of Cooperation, namely respondent number 1.
1 unit.
Expeditiously consider the representation dated
16/3/2026.
16/3/2026, stated to have been filed by the petitioner and pass appropriate orders thereon. With this order be carried out in a period of how much time?
Lordship, 2 weeks.
Weeks from the date of receipt of a certified copy of this order. Till such an order is passed, the benefit of interim order dated through and through will continue. Extend this.
Lordship.
Petition accordingly stands disposed of.
Lordship.
Mr.
Authorized.
Gauhati.
I'm obliged. Selling a transfer order, CRPF person has been transferred out to. He's right now in Silchar, the counter insurgency school. He's been transferred out to Odisha. Transfer order is at page 21. Earlier also, before the transfer order is issued, he had referred, my lords, he sought extension
What is the ground for transfer? The ground for exemption?
My lord, his wife had some issues with after the child was born. And now that after my lord,
The notification does not include that.
no,
does it?
but my lord, that was that I had preferred a representation on page 18, my lord, even before the transfer order was issued. In the month of September 2025, which was even forwarded by the commandant, headquarters of that company commander, my lord.
Page 18.
18, my lord.
So that is application for extension of transfer period.
Period, my lord, that by 1 year.
Why?
Right, that being there by my lord, because I knew that this transfer of 2000 December was coming, annual transfer. So I wanted, my lords, that I may be exempted.
Why?
Because I have to take care of my wife, my lord. The medical documents starts at annexure 4.
Is there any instance of giving exemptions like that?
No, my
Any
that I
rule?
understand, my lord, but these remain unanswered, my lord, because it was preferred to the proper channel. I don't know what happened to this man.
It was considered previously before his representation was considered. Lordship, he was supposed to be transferring Summer Singh transfer 2025. He submitted a representation that was considered. He had also filed a petition at that time. So we have given him 1 year extension. Again, he came up with the same prayer. And out of his 12-year service, more than 10 years, he is in home station. And it's 1 person each and every time. And this is not such a big problem. At the time of delivery, she had suffered from some
That I admit, my lord, because no fresh
the
medical
documents
documentation
were up
is
to
there.
3 on March or up to only November 2025. And now, Lordship, as there was no stay order, he was transferred to this Cobra battalion, and he has to go for training, and everything is already likely to be coming start from next week, Lordship. So it's a batch. He is also in that batch of Cobra battalion, and it's a very expensive training. And in that situation, Lordship, and he is not eligible, Lordship. Had he been eligible, that is a different.
Eligible mean?
But for not to transfer, Lordship, I'm saying that his case for not to transfer or not to retain him, that he is at this stage, there is no such ground, Lordship. Because similar prayer he had made last year also.
That I learned.
So we have given him already 1 year extension. Each and every time, Lordship, if we give the opportunity to one person, that is not possible in all India service like
Yes.
At this juncture, I'll have a limited travel. Let me file a representation. Let them dispose it at 1 week.
I have
just a week.
Already stated, it's likely to be starts next week, Lordship, and it's not for a single one; it's a batch.
That I understand, but let me have a
for 1 week.
representation, my lord.
What is your issue here? Your wife is
wife is suffering, my lord. Lordship will find the medical documents which starts at annexure 4, annexure 4 series from my lord page 22. And some hepato, I don't know.
Those documents, page 23, those are March 2000.
No, one is there, my lord, 5/11/25.
5/11 also, Lordship, that is only not much. Vomiting, nausea, bloating, and weakness. Hepatosplenomegaly. Fatty liver, etc. Lordship. So it's not that, and it's not included in those specific diseases also, Lordship.
That case, my lord, I also know I have a very big case out here, my lord. So I'll leave it to Lordship. Because I also advised him to get proper fresh medical reports, which he didn't pay any heed.
Are the relatives of the members of the forces, they can avail medical facilities in the group center hospital?
Yes, hospital? If they come with this, that the place which I'm being rotated out, if that has a proper medical facilities, I have no issues of that.
But these documents are also by private medical hospital.
So you go and
Just
Get yourself examined.
yes, madam. That is what I'm submitting.
Where are you transferred?
Orissa, madam.
Orissa is bound to have.
Only that if that comes from them, that place where they're
No,
posting
the
me.
place, we don't know where.
202, madam, but it's, I checked in the internet also, madam. It's,
Are any medical facilities available?
Definitely, Lordship, there must be.
202 battalion
but-
Cobra, madam. Page 21, annexure 3, serial number 2.
Can you get it by Friday?
Medical facility, Lordship, Lordship, kindly see the documents, Lordship. These are of May, November only,
We are
and
not,
those were
we are not on
Lordship.
not on these. We are on these in the event. There is some, you see, there are, we can direct him to appear before the group center for a re-evaluation of his wife.
Lordship.
That will entail some time. You'll have to examine, give a report, this, that, everything else.
Lordship, Lordship.
If there is a medical facility available, you go and appear there. I mean, wife, go and appear.
You
before them.
accompany me, madam. I will also happily go there, madam. Just
Only thing
So-
is that whether there are medical.
Whether it is actually at the battalion or in a nearby place,
nearby
that
GST,
nearby there will be
Battalion
definitely
is
there.
not necessary.
Lordship, that
it's not necessary.
Not necessary. You give it to us 10:30 in the morning.
Well, it's
On
getting
Friday.
Monday, madam.
Lordship.
I have to go
next week, Lordship, that battalion.
Monday, madam. I have to go to Pesco Mall.
That
Monday.
training, no, because I want to close it early, Lordship.
Monday.
For that,
Friday-
Lordship, she will also, if she will be available, then
Your
also, Lordship.
colleague council is there, do it on Friday.
Otherwise, Friday I was out of station.
Only for that much. Lordship.
Only for that. 10:30. 10:30. If she
10:30.
comes in the vicinity.
Or
of a
even I
reasonable-
can take the instruction just now also, Lordship. But this is the last case, that is the difficult.
Friday. No,
Friday.
Friday.
List this matter on Friday, enabling the learned CGC to obtain required instructions. That's great.